Yes, Your Lordship.
Yes.
Kindly allow me to move an unlisted item, anticipatory bill, number 9 of 25. Since IO is directed to submit a report today or tomorrow of the non-bailable arrest warrant issued against the applicant.
Okay.
Halibrand.
Lordship, I beg to mention hearing item number 27, my lord. Lordship, here I'm for the petitioner, Lordship. Lordship, I have some difficulties today, so if this matter can come up after 2 weeks, my lord.
Heard Ms. Lucino, Bennett counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. Also heard Mr. V. Zimmerman, who does not opposes the prayer. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after a week.
2 weeks, my lord.
After 2 weeks on a date to be fixed by registry.
Obliged, my lord.
Lordship, I beg to mention item number 30, Lord.
30?
Item number 30.
30?
Lordship.
Yes.
Lordship, I pray that this matter come after 2 weeks, Lord.
Oh, your lordship, can this matter be fixed on Thursday?
They are praying for 2 weeks' time.
Next.
There is on 20th, your lordship, Thursday. 27,
Hearing matter.
27. 30.
Heard Miss R. Atsula Kips, also heard Mr. V. Zimumi, learned government counsel, who prays for an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed on 27th is okay. On 27th,
Fix it.
27th March.
Obliged, my lord.
Lordship, I also beg to mention item number 16 and 17, Lord. Lordship, on behalf of LP Santam, additional AG, Lordship. Lordship, I've been instructed that he has received the instruction and affidavit is under preparation. So if Lordship, may please to grant 2 weeks time, Lord.
May I please, your lordship. Lordship, I pray that this may be the last chance, lordship. This is relating to pension matters, lordship. And in fact, Lordship, so many directions were given by this honorable court, Lordship. So,
Heard, what is your name? Mika?
Mika, yes, Lordship.
Heard Miss Mika H.I., learned counsel for the petitioner. Also heard Mr. V. Zumami, learned government counsel, who submits on behalf of Mr. L. Santam,
LT Sanctum,
L.T. Santam,
additionally.
learned additional AG, and submits and prays for 2 weeks' time on the ground that the affidavit in opposition is under preparation. Learned counsel for the petitioner submits that this may be for the last time the adjournment, prayer for adjournment may be allowed. Considering the submissions made by learned counsel for the parties, the prayer is allowed. Let this matter be listed after 2 weeks.
Worship, may I beg to mention item 34? Can you list this matter after 2 weeks?
Item 35,
34. Yes.
what is your name?
I'm appearing on counsel for the petitioner, Mahaka. My name is Mahaka.
Heard Mr. Mohaka, learned counsel for the petitioner, appearing for the counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Also, Ms. S. Chan, learned government counsel, who has no objection to the prayer. Hence, the prayer is allowed. Let this matter be listed after 2 weeks.
Okay. Lordship, may I also beg to mention item 38? Currently grant 3 weeks time to file rejoinder affidavit. I'm for respondent number 5. 38.
Lordship, I'm here, appearing here on behalf of the petitioner.
Yes, heard Mr. C.D. Runsan, learned counsel for the petitioner. Also, heard Ms. Your
S. Chang, Lordship.
S. Chan, learned government counsel appearing for the state respondent, as well as Mr. Mohaka, learned counsel for the
Respondent number 5.
5, who prays for
3 weeks time to
3
file
weeks time
rejoinder affidavit.
for filing rejoinder affidavit. The prayer is allowed. List accordingly.
Obliged.
Lordship, I beg to mention item number 39, Lordship, on behalf of V. Chokre, Lordship, if this matter can be listed after 1 week.
2 weeks.
Lordship, let it come after 4 weeks, Lordship. After 4 weeks, Lordship.
After. Third, Mr. Supongwati Waling, learned counsel for the petitioner. Also, Ms. S. Chan, learned government counsel appearing on behalf of Ms. V. Shokri, learned additional AG, and seeks 2 weeks, seeks adjournment, to which learned counsel for the petitioner does not oppose. Stop, the prayer is allowed. Let this matter be listed after 4 weeks.
Obliged,
Lordship.
Please, Lordship. Lordship, I beg to mention item number 8.
8.
Lordship, I'm for the sole respondent. Allow me 2 weeks time to file counter affidavit.
This is any objection.
Your Lordship, there is an interim.
And Miss, what is your name?
And
Chris Okira on behalf of L. Iralu.
Appearing on behalf of Mr. Iral. Also, at Mr.
and Keretsu.
What is your name?
And Keretsu.
N. Keretsu, learned counsel for the sole respondent, who prays for
2 weeks.
2 weeks' time to file written objection. The prayer is allowed. List accordingly. The interim order shall continue till next date.
Yeah, please, Your Lordship. Lordship, I beg to mention hearing item number 36, Your Lordship. Lordship, here, my senior people police has been personal difficulty today, Your Lordship. So if this matter can come up after 2 weeks, Your Lordship.
Heard Mr. M. Vero, learned counsel for the petitioner, who prays for, also heard Miss S. Mary, Learned Government Council. Learned Council for the petitioner prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. Considering the grounds mentioned by the petition council, the prayer is allowed. Let this matter be listed after 3 weeks.
2 weeks. Worship, there's an interim, Lordship.
The interim order shall continue till next day.
Much obliged, Your Lordship. Lordship, I have some somewhat similar prayer with item number 21, Your Lordship. Item number 21. On a consensus prayer, Your Lordship. If this matter can come up after 4 weeks, Your Lordship.
21.
Lordship,
Same
I'm
order.
appearing here on behalf of
Same
Respondent number 2.
Lordship, there's an interim in this item number 21 as
Interim
well.
order shall continue till next day. Instead of government council, mention public prosecutor.
Obliged.
I beg
Am I
to
pleased to Lordship?
8, Your Lordship. Your Lordship,
Item number?
this matter may be listed on 25th of March, Your Lordship. 28.
Now
From the
let it
hearing.
be in the first week of April. Item number 20.
28, Your Lordship.
You are Miss?
In a holy, Your Lordship.
Yes, Miss Ina Hali.
I'm appearing for the petitioner.
Mr.
Lordship, this is pension matter. So there's urgency. Who may be fixed next week on Tuesday, Lordship.
You are praying for 20. Tuesday is okay for you. Okay, heard Mr. Watizami, Learned Counsel for the petitioner. Also heard Miss Ina Holly, Learned Government Council, who prays for an adjournment on the ground of
I have some personal difficulties.
on the ground of personal difficulty. The prayer is allowed. Let this matter be listed on
25th.
25th of March.
Lordship.
Lordship, I also beg to mention item 35, Your Lordship. From the hearing list, Your Lordship. I've
Yes.
taken the consent of the petitioner, Your Lordship. This matter may be listed after 2 weeks, Your Lordship.
Heard. You are for the,
Petition Lordship,
what's her name?
our Mayor Lordship, on behalf of Mua Jamil.
Heard Miss R. Mary, Learned Counsel for the petitioner. Also heard Miss Ina Holly, Learned Government Council, who prays for an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed after 2 weeks.
Much obliged, Your Lordship.
Lordship, I beg to mention item number 31-3,
1-3.
Lordship. If your Lordship may be gracious enough to kindly grant us a week time to file our AIR.
You are for,
We are for the petitioner on behalf of Mr. Mua Jamil.
heard Miss R. Mary,
Lordship,
Learned Counsel for the Learned Counsel appearing for Mr. Muaz Zamir, Learned Counsel for the petitioner. Also heard Mr. N. Angami, Learned Government Council, Senior Government Council. You are appearing in this case.
No, Your Lordship.
Who is
I'm not-
appearing for the
I'm not
government?
this matter.
Who is appearing for the government? Heard Mr.
M. Longkumar, Your Lordship.
M. Long Kumar. You are appearing for government,
Yes, Your Lordship.
Learned Government Council. Learned Council for the petitioner prays for 2 weeks' time for filing,
a week's time, Lordship.
1 week's time for filing reply to affidavit in opposition filed by the respondent side. The prayer is allowed, list accordingly.
May I please, my lord? Lordship, I beg to mention item number 37. It's a consensus prayer, Lordship. This matter can be listed on next Tuesday, 25th, Your Lordship.
25th, we have fixed matters. Let it be in the first week. Otherwise, again, there will be prayer for adjournment.
It's coming on Monday.
Monday, then, Your Lordship.
Lordship, it's a short item. It's a short item because my appointment is being challenged by the petitioner. However, they have not challenged my appointment model. It's a short matter.
You are ready on Monday?
Lordship,
Heard Miss, what is your name?
Shisa Jamir, Your Lordship.
Right. Also at Mr. N. Angami, learned senior government advocate, as well as Mr. N. Muzoi, learned counsel for respondent number 3. Learned senior government advocate prays for an adjournment. The prayer is allowed. Let this matter be listed on Mondays
24.
on 24th.
It's a fixed item.
May it please your lordship. Lordship, I beg to mention hearing item number 22, lordship. Lordship, if this matter can come up after 2 weeks, lordship. 22.
I've already responded. No objection.
Heard Ms. Mika H. I, learned counsel for the petitioner. Also heard Ms. What is her name?
Tushi Jamir.
Toshi Jamir. Learned counsel, government counsel,
No, I'm for the respondent, private respondent number 1.
learned private counsel for private respondent, as well as Mr. M. Longkumar, learned government counsel. Learned counsel for the petitioner prays for
2 weeks, lordship.
2 weeks time, which is not objected to by the respondent's counsel, hence prayer is allowed, list accordingly.
Lordship, in meantime, if we may be allowed to place the translated copy of the LCR before the registry, lordship, in meantime.
The petitioner is allowed to submit the translated copy of the trial court record before the registry to compare the same. Where is the original record?
Lordship, it's in the registry.
It is with the
Yes, we were given the photocopy of it, lordship.
registry shall compare the same. Registry shall verify the same and place it with the records on the next date fixed.
May I please, Lordship?
Much
I beg to mention item 31. So 2 weeks time may be granted to file the reply to the additional affidavit filed by the government.
Heard Miss, forgot your name.
Tushi Jamir.
Heard Miss Toshi Jamir, learned counsel for the petitioner,
For the
who is
petition.
appearing for the government. Also heard Miss Livika, learned government counsel. Learned counsel for the petitioner prays for 2 weeks time for filing reply to the affidavit in opposition filed by the
Additional affidavit.
for filing an additional affidavit. The prayer is allowed. Let this matter be listed accordingly after 2 weeks.
Obliged, Lordship.
Lordship, may I be pleased to mention hearing item number 23 and 24, your lordship. Your lordship, if it can come after 4 weeks, your lordship.
Petitioners,
No objection.
heard Ms. Lushino, learned counsel for the petitioner. Also heard Ms. Livika, learned government counsel, who prays for 4 weeks time, 4 weeks at time. The prayer is allowed. Let this matter be listed accordingly after 4 weeks.
Lordship, I also beg to mention item 6, your lordship, if it can come after 2 weeks, your lordship. Item 6.
No objection, Lordship.
Heard Mr. Supungwati Valing, also heard Ms. Livika, learned government counsel, who prays for an adjournment for 2 weeks, which is not objected to by the petitioner's counsel. Hence, the same is allowed. List accordingly.
2 weeks.
After.
Lordship, I also beg to mention item number 15. Your lordship, here, I was instructed to bring his diary, your lordship. However, when contacted, your lordship, it is informed that the IO is out of station, your lordship. So she personally informed me to take some time, your lordship. So if it can be posted on 1st April, your lordship.
Yes, your lordship.
Meantime,
You are on interim.
No, not your lordship.
Okay, heard Mr. What is your name?
Zakato Chishi.
Zakato Chishi, learned counsel for the petitioner. Also heard Ms. Livika. You are public prosecutor also.
Yes, your lordship.
Learned public prosecutor who prays for some more time for producing the case diary. In this case, the prayer is allowed. Let this matter be listed on 1st of April.
1st April.
Much obliged, your lordship.
May I please, your lordship?
May I please, my lordship? Lordship, I beg to mention item number 29.
This matter can be listed next Thursday, my lord, on 27th.
Not next week, next to next week.
Then the lordship, the
In the first week of April, you can choose it.
third, your lordship,
3rd April.
3rd April, your lordship.
Heard Mr. N. Angami, learned senior government counsel who prays for an adjournment which is not objected to by the counsel for the petitioner. Stop, hence same is allowed. Let this matter be listed on 3rd of April, 2025.
Deeply obliged.
May I please, your lordship. Lordship, I beg to mention item number 25, lordship, in the hearing matter. Lordship, since the principal counsel is indisposed, let it come up after 4 weeks, lordship.
Heard Mr. C.D. Runsing. What is the reason?
The principal counsel is indisposed, lordship.
Lordship, I was informed that the counsel for the petitioner's mother-in-law
Oh,
is not well.
Okay, heard Mr. C.D. Runsing, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel.
It can be listed on the 1st of April.
Okay. What is your name?
G. Kamai, on behalf of AG Mom.
G.
Kamai.
Kamai,
Yes.
learned counsel for the learned counsel submitting on behalf of
AG Mommy.
A. Zimomi, learned counsel for the petitioner.
Your lordship, there is an interim.
Also heard Mr. Who is appearing for the government side? Private respondent.
Respondent to
What is your name?
Resokira.
Krizokira, learned counsel for the private respondent,
I'm for the private respondent, respondent number 3.
as well as Mr. Areng Long, learned counsel for respondent number 3. Who is appearing for the government?
Yeah, appearing for 1 and
Krizokira is appearing for 1 and 2. Areng Long for respondent number 3. And Miss Livika for the government respondents. Your prayer was for to
First
fix
of
it on. The prayer is allowed. The prayer for adjournment made by learned counsel for the petitioner is allowed. Let this matter be listed on 1st of April.
Your lordship, there is an interim.
Interim order shall continue till next day.
Nothing else.
Your lordship, I think the state is not a party here, your lordship.
But
1 and 2 has already been appeared by the.
But- government advocate's name has been shown in the constitution.
Your lordship, they are appearing for the department, NIDC, your lordship.
Okay, then this name of Miss Livika should be not there.
This lordship. Heading last item 40. If I'm for the petitioner in this petition, maybe that this matter will be listed next week.
next week,
In view of other fixed matter, this matter may not be reached.
after 2 weeks. In the first week of April. Heard Mr. Watizamid, learned counsel for the petitioner who prays for an adjournment. Also, who is appearing for the state?
Your Lordship, I'm appearing on behalf of Ajungli, Your Lordship, my colleague. Lordship, he has his feet in the outer court.
The Miss Livika appears for Mr.
Ajungli, Your Lordship.
Ajung, Miss or Mr.
Mr.
Mr. Ajungli, learned government counsel. The prayer for the adjournment by the petitioner is allowed. Let this matter be listed on in the first week of April on a date to be fixed by registrar.
Blanche.
Thank you, Sir Lordship. Lordship, I'd like to mention item number 20, my lord. Lordship, here, service report on respondent number 1 to 8 is still awaited, my lord. So if this matter can come up after 3 weeks, my lord.
But Ms. Lushino, learned counsel for the petitioner who submits that the notices issued to respondent number 1 to 8 have not yet returned and service is still awaited. Stop, await further. List this matter after 3 weeks.
Lordship, there's an interim if they
The
can.
interim order shall continue till next day.
Oblige, my lord.
Please, Your Lordship. Lordship, I beg to mention item number 7, Your Lordship. Here, the living counsel is from Gauhati, Your Lordship. He has some personal difficulty today, Your Lordship. So this matter can come up after 2 weeks, Your Lordship. No.
Heard Mr. M. Vero, learned counsel for the petitioner. Also heard Mr. Z. Kulnu, learned counsel for the respondent. Learned counsel for the petitioner prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner, Mr. Ankit Todi, who is an outstation lawyer. Considering the ground, the prayer is allowed. Let this matter be listed after
2 weeks, Your Lordship.
2 weeks.
Just an interim also. Your Lordship.
The interim order shall continue till next day.
Much obliged, Your Lordship.
Blanche, Your Lordship.
For motion, item number 1.
May I please, Your Lordship?
Yes.
This contempt petition is filed for non-compliance of this honorable court order dated 13/5/2024, Your Lordship, wherein this honorable court has directed the state respondents to regularize the service of the applicant petitioners, Your Lordship. And till date, Your Lordship, there is no compliance from the side of the department, Your Lordship. 6 months have been expired in the month of November, Your Lordship. Therefore,
We are issuing notice.
yes, Your Lordship.
Heard Ms. R. Atsula Kips, learned counsel for the petitioner. This civil original contempt petition has been registered on filing of a contempt application under section 11 and 12 of the Contempt of Courts Act 1971. Read with relevant rules in this regard and Article 215 of the Constitution of India, alleging willful disobedience of this court's order dated 13/5/2024, passed in WPC number 178/2023 by the respondents. Issue notice to the respondents. The petitioners shall take steps for issuance of notice to the respondents by registered post with heading,
5 days may be granted.
as well as by usual mode within a period of 5 days from the date of this order, returnable after 4 weeks. List accordingly.
Obliged, my lord.
Item number 2.
May I please the Lordship?
State has filed this one.
Lordship, that's it.
What is this?
Lordship, an application has been filed under section 438, read with 442 and 5 28 of the Bharatiya Nagrik Suraksha Sanhita BNSS 2023. Here, Lordship, I have filed the present revision petition, Lordship, excelling the order dated 3/10/2024.
Where is the impugn order?
The impugn order is at impugn order starting from page 34, Lordship. Page 34, and the relevant portion will be at page 46. Paragraph 30, Lordship, if I'm allowed to read.
Page 46.
Page 46. This is the order passed by the learned CJM, Kohima, Lordship. Order dated 30/10/2024, Lordship. IN number 90 of 2024, arising out of GR number 179/12, page 34, Lordship. And the relevant portion will be at starting from
The respondents were discharged.
Lordship, here the ground taken by the observation made by the lower court below was that, as such, upon considering the police report and the accompanying materials, and after considering the submission of both parties, this court considers the charges against the applicants under section 409, 420, 471/120B IPC to be groundless. Here, the observation is to be groundless and deem it fit to discharge the accused person, like the applicant, and here are
Mr.
no
Zimumi,
grounds.
we are issuing notice.
Lordship, Lordship.
Heard Mr. V. Zimumi, learned public prosecutor. This application under section 438, read with section 522/28 of BNSS, has been filed by the state of Nagaland, impugning the order dated 3/10/2024 passed by London Chief Judicial Magistrate Kohima in IA number 90/2024, arising out of GR case number 179/2012, corresponding to State Crime PS case number 5/2012, whereby the respondent was discharged of offense under section 409/420/469/471/120B of the Indian Penal Code. I have gone through the grounds taken by the by the petitioner in the revision petition. Let the notices be issued to the to the respondent, and let the trial court record be called for.
Lordship.
The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD, as well as by usual mode within 7 days from the date of this
Lordship.
order, returnable after 4 weeks,
Lordship.
list accordingly.
For motion, item number 3. May I please, my lord, is there some error in the petition? I may be allowed to withdraw with liberty to file affairs.
Heard Mr. Pakinri Chapo, learned counsel for the petitioner. Also heard Ms. S. Mary, learned public prosecutor, Nagaland. Learned counsel for the petitioner submits that some inadvertent error has crept in the criminal petition filed by the petitioner. Hence, he prays for allowing the petitioner to withdraw the instant criminal petition with liberty to file an appropriate application. The prayer is allowed. This case is dismissed on withdrawal with the liberty sought for granted.
This is highly obliged.
For admission, item number 4.
Mr. Lordship, on behalf of Moy Imchen, kindly list this matter after 2 weeks.
I'm for the petitioner appearing on behalf of N. Longcomer.
Heard. Heard Miss
Rebecca.
Rebecca, learned counsel appearing for Miss on behalf of Mr. N. Longkumar, learned counsel for the petitioner. Also heard Miss
Pichano, on behalf of Moy Imchen.
Apichano, appearing on behalf of Mr. Moaim Chen, learned senior government
Lordship.
advocate, who prays for an adjournment for
2 weeks.
2 weeks, which is not objected to by the counsel for the petitioner. Hence, same is allowed. List this matter accordingly.
I will pledge.
For admission, item number 5.
Your Lordship, counsel for the state is attending court 1. So I pray that the matter may come up on Tuesday on 25th.
Okay. Heard Mr. Supungwati Wali, learned counsel for the petitioner. 25th,
Tuesday.
how many cases are there? You have any idea? What is the matter?
Your Lordship, as service recollection, Your Lordship. It's a simple matter because in your affidavit, they have clearly stated they are considering the case.
Okay. Learned, it has been informed that the learned government council is on legs in some other court. Hence, this matter is adjourned for the day. Let this matter be listed on 25th of March.
Obliged.
Item number 9.
May it please, my lord. Lordship, the petitioner here is the attorney holder. The executant, who is the proprietor of the firm, is his father. His father, the executant, is unwell, so he has been taken to Gauhati for treatment. They were supposed to return last week, Lordship. However, the doctor has advised them to stay for about a week more, Lordship. So, which is why the reply, which is to be signed by the petitioner.
Could not be. You,
Yes,
you
yes.
need some more time.
Yes, my lord. So kindly can me to be on the safe side 10 more days, Lordship.
Heard Mr. Senti Younger, learned counsel for the petitioner, who prays for some more time to file an affidavit in reply to the affidavit in opposition filed by the respondent sides, on the ground that the petitioner is, there is some, no, on the ground, not necessary to mention.
Yes, my lord.
The prayer is allowed. Let this matter be listed after 2 weeks.
My lord. Deeply obliged.
Item numbers 10 to 12.
Lordship, here I want to file an additional affidavit placing on record the completion certificate, which was issued yesterday only, Lordship.
What is the matter?
Lordship, this is a case where the CBI has conducted an investigation and then stated that, Lordship, I have withdrawn excess payment, Lordship. Excess payment, which I never did, Lordship. In fact, the state government still owes me more than 1 crore, Lordship. But because of this case, that money has also not been given to me, Lordship.
So you have prayed for quashing?
Yes, I have prayed for quashing, my lord.
You have any objection? Counter affidavit? Additional affidavit?
Additional affidavit, I want to place on record the completion certificate. In the report also, it is clearly stated that no completion certificate has been issued, Lordship. Because of the Lordship,
Okay. Okay, I'm allowing.
Crux of the case is that, Lordship, it's simple, Lordship. There are 6 allegations. Those 5 allegations are not against me. Those are against different firms and different contractors, Lordship. I am only the executant of one road, Lordship. Now, that road has to reach the High Court New Complex. After reaching the High Court New Complex, the road has to be, the new High Court building has to be encircled by the road. But because of the new High Court building being under construction at that relevant point of time, Lordship, and huge machinery was deployed, building machineries and construction equipments, construction materials were dumped, Lordship, on the construction site, which is why it was discussed and decided that the road, that portion encircling the High Court building will be executed only after the main High Court building is.
Now is it over?
Yes, it is over. It is over. Now the construction is completed, the High Court building also, and interior like electrification and tiles laying, it's going on, Lordship. So I have also completed the road.
Okay.
And completion certificate has also been issued, Lordship. I have submitted the completion report. The department officers, the engineers, they have come and.
Who is appearing for CBI?
Yes, Lordship. I have taken his consent also, Lordship.
I'm for respondent.
Yes,
for the
he is unavailable today.
Heard Mr. Senti Younger, learned counsel for the petitioner. Also heard Mr. V. Zimo.
And Lordship, if the matter can be listed with consent, Lordship, I have already obtained this next Thursday, Lordship. In the meantime, I'll be filing the additional affidavit today itself. I have informed him also.
Okay. Also heard Mr. V. Zimumi, learned counsel for respondent number 2. Learned counsel for the petitioner prays for some time for filing an additional affidavit for placing on record the
Completion
completion
certificate.
certificate in respect of the construction of remaining part of road within the new High Court complex. Around the new High Court complex.
My lord.
He submits that he has informed about his prayer for adjournment to Mr. Ben Deng
My lord.
Abeng, learned public prosecutor for CBI. Considering the submissions made by learned counsel for the parties, the prayer is allowed. Let this matter be listed
Next Thursday, my lord.
on 27th of March.
I am deeply obliged, my lord.
For orders, item number 18.
Yes, Lordship. Lordship, I have instructions to appear on behalf of respondent number 3, Lordship. I'll be filing my Bakalatana during the course of the day.
1 and 2 have appeared.
Speed, your lordship. Is
1
respondent
and
number
2,
1.
Mr. Angami is appearing for 1 and 2.
Lordship, Mr. KV.
KV
Yeah,
Angami.
yes, he's on his leg at court number 1, your lordship, right now.
Okay. Heard Miss, what is your name?
Shisa Jamir.
Sisha
Jamir.
Jamir, learned counsel appearing on behalf of Mr. Muazzamid, learned counsel for the petitioner. Also heard Mr. N. Angami appearing on behalf of Mr. KV Angami, who is on legs in court number 1. Also heard Mr.
Kiroba,
Kiroba, who submits, learned counsel who submits that they will be filing. Have I pronounced your name correctly? Who submits that he will be filing wakalatnama for on behalf of respondent number 3 in the course of the day today. In view of submissions made by learned counsel for the parties, let this matter be listed for admission hearing in when? After 2 weeks. After 2 weeks on a date to be fixed by registry.
For orders, item number 19.
May I please, my lord? Lordship, even this matter is handled by KV, lordship. I think he's yet to file this.
Yes, yes.
Counter affidavit. has
Counter affidavit is yet to be filed, Lordship. Yes.
Heard Mr. Senti Younger, learned counsel for the petitioner. Also heard Mr. KV, Mr. N. Angami appearing on behalf of Mr. KV Angami, learned government counsel. It appears from record that the state respondent has not yet filed affidavit in opposition. Some more time is granted to for the same to the state respondent. Let this matter be listed after 2 weeks.
3 weeks, Your Lordship.
3 weeks on a date to be fixed by the.
Lordship, there's an interim.
The interim order shall continue till next day.
Deeply obliged, Lordship.
Obligement.
For hearing item number 26.
Lordship, my senior is in another court right now, so if it can be passed over for a time being, he's in the other court.
Timing or for the day?
For the time being, Lordship, we want to take up the matter today, so
Okay, for the timing, we are passing it.
obliged, Your Lordship.
For hearing item number 32.
Lordship, kindly accommodate this matter also is handled by KV, Your Lordship. If it can be, this is after some time, my lord.
Lordship, if I can make my submissions in the meantime.
No, let him.
Yes, Your Lordship.
My lord, my
This is a criminal appeal.
Yes.
Lordship, Lordship. Lordship.
If it can be accommodated, Your Lordship, listed after some time, my lord.
Today it's.
Today,
Okay,
today, Your Lordship.
okay. We'll take
We
it up.
can go through the facts, not necessarily on the question of law.
Whether Mr. Angami is ready, Mr.
Yes,
KV.
yes.
Yeah, I'm told he's ready,
we
my
have
lord.
He's
discussed-
ready.
Yes,
yes.
he's ready, I'm told.
Then you can start with facts.
Yes, my lord.
You remain.
Because I believe after this, there is no more item, and item 26. Well, then,
No, Lordship, there are 3 unlisted, there are 3 hearings in the supplementary list.
then we can wait for my learned friend in that case. If there are more items to be called.
Yeah.
Okay. Then we'll take it up after some time.
My lord, my lord.
Deeply obliged, deeply obliged.
From the supplementary cost list for motion anticipatory bail number 9 of 2025.
Yes, Mr. Chapo.
Okay, please, Lordship. Here the petitioner has apprehended he will be arrested as the learned chief legal magistrate Prima by his order 11/3/2025 had directed the IO for issue of fresh non-bailable arrest warrant and to submit his report on or before 21st.
This is pending investigation or charge sheet has been.
Pending investigation, the main accused are on bail. And the IO, based on its own source, have straight away prayed for arrest warrant for arresting the applicant. In fact, the applicant name is not even in the FIR.
What
So
is the
maybe based
offense?
on the statement of the accused.
Okay. What is the offense? Where is
It's a
the
theft, my lord. It's a minor offense, theft. It's a not
theft of?
theft of bike. The FIR on page 16, the FIR application.
Theft of bike is a minor offense.
Minor in a sense, it's a non-bailable, but
It is a-
it's a compoundable offense with the owner undertaking the permission of the court. And the accused are on bail. 2 accused are on bail. 2 main accused.
Okay. Well, let us go through the affair.
FIR page 16, annexure 3.
Nobody is named in the affair.
I beg your pardon, my lord.
Nobody is named. No accused has been named in the FIR.
Yes, no. In the FIR also, no accused have been.
What is your case?
My case, my lord, I'm willing to cooperate with the investigation officer, but since my sister wedding was just held yesterday, and I may be given some time to appear before the IO, and I live permanently in Taluke, but the parents' address is at Tamai, so it may take some time for him to travel back. He's a permanent resident of Taluke, and there's no chance of absconding also. He's willing to cooperate with the.
Where is the order of the CJM issuing warrant against you?
My lord, I have annexed page on 21, annexure 6, page 2.
Yes, Miss. Yes, Miss Levika.
Please, Your Lordship. Your Lordship, I just contacted the IO. And it seems that Your Lordship, they went personally to the place to arrest the accused. However, on reaching the native place, Your Lordship, he was not found. And it was informed that he went out in search for pigs for the wedding, Your Lordship. So, Your Lordship, the IO informed the wife of the petitioner that to let the accused appear today. Now, instead of appearing before the IO today, they have moved the anticipatory bail, Your Lordship. So, Your Lordship, the IO is actually stating that he's supposed to come before, he's supposed to appear before the police station today. And we have informed the wife, and the wife specifically said, yes, we will let I will let my husband appear before the police station today. But instead of actually appearing before the police station, they have.
No, he will appear. He's saying that he will be appearing now.
No, no, not before, yes, before the court, Your Lordship, before the court. Because the production is tomorrow, Your Lordship. It's an arrest of warrant, Your Lordship.
He has to be produced before the court.
Yes, Your Lordship, before the court tomorrow, Your Lordship. So he was informed to appear today, Your Lordship.
Why before the court?
Your Lordship, because Your Lordship, arrest of, if you can kindly see
Okay.
the case, Your Lordship.
Before the court, when is the date fixed?
Your Lordship, on 21, it's tomorrow, Your Lordship.
You appear before the court tomorrow?
Will
Yes, Your Lordship.
put a halt on the,
actually, the case
your
is that,
arrest.
his sister wedding was held yesterday, and he need time to make arrangement. And since he is the eldest in the family, so my lord, some period may be extended, my lord. Interim protection, my lord.
No, Your Lordship. How
He's
can that
willing
be,
to
Your
cooperate
Lordship?
with the investigative team. Moreover, he's not in the fire. In the main accused are on bail, and for the purpose of investigation, he's willing to cooperate. And my
Your
lord,
Lordship is still under
interim protection
investigation.
may be granted in the interest of protecting his liberty, my lord.
Let somebody appear, your counsel appear before the CJM tomorrow.
Yes, my lord. I can.
And seek
Yes, my lord.
extension of time.
Yes, Your Lordship, that would be the proper procedure, Your Lordship. In fact, he was supposed to appear today. Instead of appearing before, after giving assurance that he will appear, Your Lordship.
No,
Instead
you
of
could,
going there, he is come before the court.
instead of coming to High Court, you could have gone to
Yes.
the Court of
Oh.
Chief Judicial Magistrate.
My lord, actually, I apologize. I failed to submit before, but actually, I have approached the learned principal district and session court. But
No, why Sessions Court? You could have appeared directly to the Sessions
interim
Court
protection.
for interim
yeah, for
protection.
interim
Then what
protection, since
happened?
arrest warrant.
What happened?
But the learned session judge,
Rejected your
uh,
prayer.
yeah, I refused to grant me interim protection.
Where is that rejection
I've
order?
annexed on page 24, my lord. Since arrest warrant is issued, the learned session judge declined to intervene. So I am compelled to approach it on Honorable High Court.
No, you withdraw that petition.
Yes, my lord, since I have no option, I'm compelled to withdraw the petition.
Then you withdraw here also if.
Yes, your lord.
My
Your
lord,
lordship-
my lord, the applicant is treated like a hardcore criminal. He have no criminal records, and just because of some allegation by the co-accused, he was treated like a hardcore criminal, my lord,
Why the warrant was issued? Let us read.
for the purpose of investigation. But the thing is that main accused are already on bail, my lord, and there's no purpose of putting him behind bar when two main accused who stole the bike are on bail. There's no point of putting
How
him
do you
behind bar.
know that they are the main accused?
Main accused, my lord,
Because you don't know where the investigation is going, in which direction the investigation is
my
going.
lord, because the two accused were arrested based on some.
Yes, two other accused persons were arrested. They are granted bail. Where is the bail order?
My lord, these are the bail order.
Where is the earlier order, first order by which non-bailable warrant of arrest was issued?
My lord, unfortunately, I did not obtain a CTC of the first order
No,
because of
otherwise
the
we-
lack of time. But the next latest order, which was passed on 11 March.
No, how will we know on what ground non-bailable warrant were issued against you? Unless we can appreciate.
The IO has prayed for the purpose of investigation. The IO has prayed for issue of non-bailable arrest warrants. But my lord, the IO have option to summon or to issue notice for the applicant to appear before the IO.
Whether notice under 35(3) was issued against
No,
you?
no. Direct, he prays for arrest warrant. my lord.
Okay.
That's abuse of process.
Your lordship-
Notice has to go.
That has to be ascertained because your lordship, now your lord,
Oh,
interesting
yes,
is
that can be ascertained only
tomorrow your
after
lordship.
perusal of the case diary.
Yes, and
Because we don't know.
Yes, my lord. In interest of protection of his personal liberty as granted by Article 21 of the Constitution, my lord. Some days may be given, my lord. And
Okay, heard, Mr.
lordship, before this honorable court passing here, or your lordship, if you can kindly see page 20A of the 20A, your lordship.
Yes.
Your lordship, again, product two, your lordship, I would like to read product to your lordship. On reaching Tamai police station on 12/3/2025 at around 11:30 AM, so and so, a requisition for local police guide was prayed and accordingly went to the residence of the warranty, your lordship.
Now, where are you reading?
Your lordship, page 20A, your lordship.
20A.
Yes. Type copy.
This is a type copy of
Yes, your lordship.
Panchnama.
Since this is more legible, I mean.
Yes, please.
On reaching, your lordship, Mary.
Second paragraph.
Yes, second paragraph.
Yes.
On reaching Tamai police 2025 at around 11:30 AM with so and so, a requisition for local police guide was prayed and accordingly went to the residence of the warranty. However, during the visit to the resident, the warranty was not found present at his residence. For his mother and friend's he went out in search of pics for his sister's wedding, and also his phone was switched off. Therefore, the house search was conducted in presence of independent witnesses. Your lordship, what I would like to state is that, your lordship, as I right now in the premise of the court, I contacted the IO, and IO told me that a petitioner's wife gave an assurance that he will make an appearance on 19, that is today. Now, interestingly, on 18, they have also moved anticipatory bail before the district and session judge, your lordship. If they can go before the district and session judge for anticipatory bail, then he is well aware that he should appear before the court, before the police station today, your lordship.
No,
But he did not go in, he is coming before
but-
this court, your lordship, with
No,
unclean hands. your
he is not appearing before police because he is apprehending that as you are having a non-bailable warrant of arrest.
That's why, your
You cannot,
lordship.
you may not grant him bail. You cannot grant him bail. Police cannot grant him bail.
Yes, that's why, let
Therefore,
him
he
go,
approached this court.
as a correct procedure, let him go before let him appear before the court tomorrow. It's tomorrow. Let him go and let him apply for a proper bail, not an anticipatory bail, not by
Yes,
way of
that
anticipatory bail.
one option is available.
Yes, let them go before the CGM tomorrow and obtain bail if so required, Your Lordship. But at this point, granting anticipatory bail, Your Lordship,
But is there any bar for
no,
filing
Your
an-
Lordship, that is my humble submission, Your Lordship. That is up.
because he is apprehending arrest,
He's apprehending, but Lord, seeing
not necessary.
that too after seeing the case
Case
diary, Your
case
Lordship,
diary.
I will able to satisfy this.
We'll
honorable court.
call for case diary.
Yeah, but now seeing the situation right now, Your Lordship,
When can you appear?
no, it's fixed
I did, my
tomorrow,
lord,
CGM.
I may be given 5 days, my lord,
Your Lordship,
because I have been arranging for my sister's wedding, and there are lots of work to do at home.
No, that
after the wedding.
when the court has.
Then now, right now, he's in Tamai, and it's difficult to get
How far is Tamai from?
Tamai from Peren. It will take another 5 hours, so it will take nearly 8 hours to reach Kohima. It's impossible to reach tomorrow. I'm just praying for some days, 5 days, 5 days, interim protection, my lord. And Supreme Court have clearly stated that a citizen must not be unnecessarily.
Then you have not
harassed.
received any notice under section 35 BNSS.
Nothing has been sent. No notice
That
someone has been sent.
only
In fact, the police IO have to exercise that, but nothing. He straight away prayed for arrest warrant when the main accused, 2 accused were on bail, and there's no purpose of putting him in custody.
Mr.
My lord, I have relied on this. As 1982 SCC.
Akinri Chapo, Lanet.
Your Lordship, as far as the notice is
On
concerned.
pair 26, my lord,
unless
if I
until
may be allowed to
we
read
get
out.
the case diary, Your Lordship,
We'll call for the
I
case.
cannot comment on
We'll
that. Your Lord.
call for the case.
Yeah, case diary.
Akinri Chapo, Lanet counsel for the. What is this?
This is a Supreme Court ruling on granting anticipatory bail, my lord.
What it says?
It says that a citizen must not be unnecessarily harassed just because there is a provision to arrest without warrant. And
Also, Miss Livika, Lanet public prosecutor. Stop. This application under section 482 of BNSS 2023 has been filed by the petitioner, Mr. Vilya P. Bo, who is apprehending his arrest in connection with Kohima North PS case number 39/2023 under section 379 of the Indian Penal Code. As the Court of London Chief Judicial Magistrate Kohima by its order dated 11/3/2025 has already issued non-bailable warrant of arrest fixing 21/3/2025 for appearance before the said court. Learned counsel for the petitioner has submitted that on that the investigating officer of Kohima North PS case number 39/2023 has approached the Court of Learned Chief Judicial Magistrate Kohima for issuance of non-bailable warrant of arrest against the present petitioner, and accordingly the said non-bailable warrant of arrest were issued against him. He submits that the Kohima North PS case number 39/2023 was registered on the basis of an FIR lodged by one Matabuddin on 12/3/2023 before the officer in charge of North Police Station, Kohima, wherein it was alleged that the bike of the informant bearing registration number NL07E B58483 was stolen from the place, stolen from where?
KCK near to the basic showroom.
KZK near Todi Basic Showroom, opposite to Jain Temple on that day. Stop. Learned counsel for the petitioner has, what is your submission, your involvement?
I'm innocent.
Learned counsel, okay. Learned counsel for the petitioner has submitted that the petitioner is innocent and in no way involved in the offense alleged in the FIR. He also submits that in the meanwhile, two other accused persons who were arrested in this case, in connection with this case, were already granted bail by the Court of Learned Chief Judicial Magistrate, Kohima, by order dated 6/10/2023, passed in I number 180/2023, arising out of GR case number 124/2023. BNS says, learned counsel for the petitioner has also submitted that the petitioner, though the offense alleged is punishable for a maximum punishment of 3 years only, he has not received any notice under Section 35 of BNSS. The affair was registered after BNSS.
No, before you.
Before that.
Before.
How before? It was on 35.
March 2023 and section is under IPC.
23 or 25?
The FIR dated is 12 March 23.
23.
12 March 23.
BNSS or Section 41A of the Code of Criminal Procedure. Learned counsel for the petitioner has also submitted that before approaching this court, the petitioner had approached the Court of Learned Sessions Judge Kohima by filing an anticipatory bail application. However, same was withdrawn by the petitioner. Learned counsel for the petitioner submits that the petitioner could not appear before the, how he will appear if he was not intimated.
Your Lordship, I'm also like wondering how he got an authorization letter on the Vakalatnama if he's seeking for 5 days, Your Lordship, because Vakalatnama, he is the petitioner, Your Lordship. How he has obtained authorization to appear before this court, the learned counsel.
No, whether
I think he's in around the.
He has filed Vakalatnama.
That's why, Your Lordship, how his signature is obtained, Your Lordship.
No,
If
can-
he's stating that the petitioner will come after 5 days, it's difficult for him. The case is filed today. It's unlisted motion. On 18, it was filed. The petitioner must be somewhere else in Kohima or in Dimapur. How he has obtained authorization letter, Your Lordship?
No, the question here is, main question which is involved is whether his custodial interrogation is required or not.
Your Lordship, Your Lordship, that I am not actually, that will be only after the case diary comes, Your Lordship. But as far as the submission of the petitioner goes, stating that it will take 5 days, Your Lordship, I'm questioning how he got the authorization letter, Your Lordship.
Well, that's because he have work at home right now because of his sister waiting.
Okay, learned counsel for the petitioner has also submitted that the sister of the petitioner got married on 19th of March 2025, and he has been busy in the ceremonies relating to the wedding of his sister, and he needs some time to appear before the court of learned Chief Judicial Magistrate Kohima. You appear tomorrow. You appear before the court tomorrow.
Yes, my lord.
You can inform the petitioner today itself. It will take 5 hours.
Yes, my lord. Unless this court pass some interim protection, my lord.
I will give you protection,
Yes, my lord.
but you appear before the court tomorrow.
Yes, my lord. Okay.
The learned counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation. However, he seeks some interim protection as the non-bailable warrant of arrest has already been issued against him by the Court of Learned Chief Judicial Magistrate Kohima. On the other hand, Ms. Livika, learned Public Prosecutor Kohima, has submitted that considering the submissions made by learned counsel for the petitioner, perusal of the case diary would be necessary for consideration of his anticipatory bail application. He also submits, what else?
Your Lordship, my submission may also be recorded that the IO.
She also submits that he has been telephonically informed by the investigating officer of not Kohima, not PS case number 0039/2023 that when the investigating officer went to the residence of the petitioner to arrest him, he could not be found there, and
Assurance was given.
By the wife of the petitioner that the petitioner would appear
Today.
before the investigating officer today. However,
Instead of appearing there, both anticipated.
However, he has failed to do so, and instead he has appeared before this court. She further submits that as the case, as the GR case number 124/2023 is fixed before the Court of Learned Chief Judicial Magistrate Nagaland tomorrow, the petitioner should not be granted any interim protection, and instead he may be directed to appear before the Learned Chief Judicial Magistrate. Stop. I have considered the submissions made by learned counsel for both the sides. When can you produce the case diary?
Your Lordship, tomorrow I can produce, Your Lordship, because the case diary is not, I think it will not take time.
Tomorrow you can produce, but tomorrow the case is fixed before.
Lordship, so, because since not police station is here, so I can actually obtain it. It shouldn't be a problem. It's up to the court, Your Lordship.
Produce it on Monday. This court is of considered opinion that the perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Ms. Livika, learned additional public prosecutor, submits that she would be able to produce the case diary on 24th 3/2024. Accordingly, place this matter on 24th 3/2025 for case diary. In the meanwhile, considering the nature of offense involved, as well as considering the fact that two of the co-accused are already released on bail and the petitioner is willing to cooperate in the investigation, he is directed to appear before the Court of Learned Chief Judicial Magistrate Kohima in connection with Kohima in connection with GR case number 124/2023 and cooperate in the investigation. To facilitate his appearance before the said court tomorrow, the operation of non-bailable warrant of arrest issued against the petitioner shall be kept suspended, and if he appears before the Court of Learned Chief Judicial Magistrate Kohima tomorrow in pursuant to the directions given by this court, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the Learned Chief Judicial Magistrate Kohima till 24th of March 2025, list accordingly.
For hearing item numbers 32 and 33.
Lordship, I am accused by the order dated 3rd of April 2023.
Just a minute. You are ready for hearing,
Yes, my lord.
Mr. Angami? Okay. What is this bail application?
Pending the criminal appeal.
Now it will be disposed of.
Yes, my lord, my lord. So I believe it has more or less become infructuous.
Okay.
By the flux of time. So we'll be concentrating on the, I'll be concentrating on the
Main appeal.
Yes, my lord. My lord.
Just a minute. Yes.
By that decision, I was convicted under the NDPS Act.
NDPS?
Yes, lordship. For 10 years, I was sentenced under I was found guilty under section 20, Roman 2, B, and C of the NDPS Act 1985, lordship, and sentenced to 10 years imprisonment.
20B to C.
Yes. 20 under bracket Roman 2, under bracket B and C, NDPS Act 1985.
20B to C.
Yes,
C
Lord.
capital C. For commercial quantity.
Yes, Lord.
Of
Ganja.
ganja.
Yes.
How much?
360 kilograms.
Yes.
Lordship, the FIR. Which is
Page,
the, yes,
page.
page 100 of the paper book.
page 100 of the paper book. This is the foundation on which the entire case of the prosecution rests, Lordship. The date, Lordship, is very important here. The FIR is dated 19.
You come this side. Hold this, so that it can be really taken. That means. Yes.
Yes, Lordship, the date is important, Lordship. It is 19 January 2022. Why it is important, I'll come in the later course of my submission, Lordship. However, for the time being, Lordship, I may be allowed to read this FIR. Do the officer in charge, Police Station Futsuro, DEF, PEC, Nagaland. Subject, Sumuto FIR. Sir, with reference to TGP order number so-and-so and SP PEC so-and-so, I have the honor to state that on 19/1/2022 at around 16 hours, mobile check post MVCP was
You're
conducted
reading
at
at page 102.
100, Lordship, 100.
100 is the form on the.
Lordship, the paper book I'm relying, Lordship, I'm relying on the paper book.
This is the paper book. Or
Lordship.
separate paper book is there. Okay.
At around 1750 hours, a Maruti Gypsy unregistered was intercepted. Upon frisking, 360 kilograms of suspected contraband ganja was recovered from the vehicle. The driver, namely the present appellant of Pezakeno village, was arrested and produced before the PS Futsuro for further necessary legal action. And Lordship, it is signed by UPC Ketokro Tero, Lordship. This is important, Lordship. UPC means Unarmed Branch Constable, Lordship. Now, Lordship, under the NTPS Act, a constable is not empowered to make arrest, Lordship. Now, in page 135, the deposition in order to show, Lordship, that the FIR informant is the one who arrested the appellant. Page 135 of the paper book. In his examination in chief, Lordship. This is his own statement, not cross-examination, Lordship. In his examination in chief.
Yes.
The PW1, Lordship.
Yes.
Oh, no, Lordship, page 137, Lordship. If FIR informant is PW2, Lordship. My apologies.
Seven is not there in the paper.
137.
That page is missing from this paper. It is 136 and then 138.
I believe there was I'm gonna 137 as well. Lordship, then Lordship, if my Lord can kindly check the index, Lordship, and instead of this, Lordship, if we can come to another issue, then in that case, we'll
No,
keep this in
you
the PN.
furnish me later on the page 137.
Yes, my Lord.
You
my
can
Lord.
continue with your argument.
Yes, Lordship.
Because 137 is missing.
Yes, Lordship.
Is there any extra paper book? Give that paper book to me. See 137 is there or not? It is there, no? Take this one.
Yes.
Mr. Angami, you have paper book? Yes.
Yes,
One-
Lordship. 137. In cross-examination, Lordship, not the examination in chief.
Yes.
137.
Yes.
It is the second answer, Lordship, the second statement. It is correct to state that at the time of arresting the accused person, no officer was available. But after the arrest was made, OC along with one Chawan came to the spot. OC is the PW1, Lordship, the officer in charge.
Okay.
Now under section 42, Lordship, there is a class of officers. And from that rank and above only, arrest, seizure, search can be made, Lordship. And the government of Nagaland, Lordship, has also issued a clear notification, Lordship, which I have annexed at page 148, the last page of my paper book, Lordship.
What this notification says? Yes.
I may be allowed to read, Lordship.
Yes.
In partial modification of this department, order number so-and-so, and in exercise of the powers conferred under subsection 1 of section 42 of the Narcotic Drugs and Psychotropic Substances Act 1985, the government of Nagaland hereby empowers all prohibition officers of related departments dealing with NTBS control, that is, Department of Excise, Department of Home, Police, and Department of Health and Family Welfare, Drugs Control Cell, from the rank of ASI, Lordship, and above, or equivalent rank in the Excise Department and Health and Family Welfare Department, Drugs Control Cell, to exercise all the powers conferred in the said Section 42(1) of the said Act, subject to general control and direction of the government of Nagaland. So, Lordship, for conducting search, seizure, and arrest under the NTBS Act.
Where the ganja was found? In a vehicle?
Yes, Lordship, in the vehicle.
So vehicle was searched by PW1.
PW2.
PW2.
Yes, he made the arrest, he made the seizure, and he made the search, Lordship. Only after, Lordship, he searched, Lordship, and he found the...
Who received the information? What FIR says?
The information was received by because the FIR is addressed to the PW1, Lordship. PW2, who is a constable, Lordship, wrote to PW1, who is the officer in charge. But at the time of search and arrest, PW1 was not there, Lordship. Only after those procedures were completed, Lordship, PW1 came to the scene, which is very much clear from the deposition of the PW2, who is the FIR informant.
No, read FIR again, 100, page 100. With what this DGP notification is, which he is referring to?
Now, Lordship, Lordship, if he is not empowered under the Act, Lordship, perhaps these notifications were issued, these directions were issued, Lordship, in order to allow them to conduct this.
What is this
mobile vehicle checkpost, Lordship? MVCP, Lordship.
No, this 11 January 2022 notification.
Yes, and SP PEC.
SP PEC
Yes,
13
Lordship.
January. What these notifications are?
Lordship, I don't have a copy of this, Lordship. these notifications. But despite that, Lordship, these notifications cannot supplant the principal statute, the central legislation, Lordship. Even if assuming, Lordship, certain powers have been given to the constable. Because under the Principal Act, Lordship, under Section 42, if my Lord, I may travel my Lord to go to Section 42 of under the Principal Statute, Lordship.
Yes.
Section 42, subclause 1, Lordship. Any such officer, power of entry, search, seizure, arrest without warrant or authorization. Any such officer, being an officer superior in rank to a peon, sepoy, or constable of the departments of Central Excise, Narcotics, Customs, Revenue, Intelligence, or any department of the central government, including.
Here the PW2 was a constable.
Yes,
He's a
Lordship.
constable.
Yes, he's a constable. UPC is unarmed branch constable.
Okay.
APC is armed branch constable, Lordship. In Nagaland, we have that kind of categorization amongst the constables.
Yes, please.
Department of Central Excise, Narcotics, Customs, Revenue, Intelligence, or any other department of the central government, including paramilitary forces or armed forces, as is empowered in this behalf by the general or special order by the central government or by any such officer. Being an officer superior in rank to a peon, sepoy, or constable of the revenue, trucks, central control, excise, police, or any other department of a state government as is empowered in this behalf by general or special order of the state government. If he has reason to believe from person's knowledge or information given by any person and taken down in writing that any narcotic drugs or psychotropic substances or controlled substance in respect of which an offense punishable under this act has been committed, or any document or any article which may furnish evidence of the commission of such offense or any illegality, acquired property or any document or any article which may furnish evidence of holding any illegally acquired property which is liable for seizure or freezing or forfeiture under Chapter 5A of this Act is kept or concealed in any building, conveyance, or in closed place between sunrise and sunset, Lordship. So, Lordship, in short, Lordship, a constable is not empowered under the Act.
Neither he may be authorized.
No, he cannot be authorized.
Under 41. He is not empowered under.
No, he is not empowered, neither can he be authorized, Lordship. Okay. Because what cannot be done directly cannot also be done indirectly, Lordship.
Okay.
Now, Lordship, that issue has already been. I'll only place one citation on this issue. 2008 SCC, Lordship.
2008
SCC.
Page
590, Lordship, paragraph 18. Here, Lordship, this is not even an appeal. Here, FIR itself was quashed by the Honorable Supreme Court. The criminal proceedings itself was quashed. Because the search, seizure, arrest, all these were not made by the empowered police officers. Paragraph 18, Lordship. It is well settled that the power under Section 482 CRPC has to be exercised by the High Court inter alia to prevent the abuse of the process of any court or otherwise to secure the ends of justice. Where criminal proceedings are initiated based on illicit materials collected on search and arrest, which are per se illegal, and we should not only a conviction and sentence based on materials, but also the trial itself. The proceedings cannot be allowed to go on as it cannot but amount to abuse of the process of the court. In such a case, not quashing the proceedings would perpetuate abuse of the process of the court, resulting in great hardship and injustice to the accused. In our opinion, exercise of power under Section 482 CRPC to quash proceedings in a case like the one on hand would indeed secure the ends of justice.
How trial court dealt with this issue? Whether this was raised before the trial court?
It was raised, Lordship. But the trial court was not impressed, Lordship. Was not convinced by this issue, Lordship. Now, secondly, Lordship, I may be allowed to take my lord to the date of Caesar, that is the Caesar memo, which is page 108 of the paper book, Lordship. 108.
Yes.
Here also, Lordship, the dates are clearly reflected, Lordship. The date of Caesar, the amount of suspected contraband that was seized, that is 360 kilograms. The date, Lordship, on top is 19/01/2022. And the officer in charge has signed the same on the next date, that is 21/2022.
And date of Caesar is?
Date of Caesar is on 19/1/2022. The top column, Lordship.
Who is the seizing officer? It is
The officer in charge himself, Lordship, PW1. Seized by, Lordship. And the name of the PW1 along with his seal appears, Lordship.
what is the name of the PW1?
Yes, Lordship, it is.
So what do you want to show?
I want to show the date here, Lordship, the date. And the next document which I want my lord to peruse is at page 120 of the paper book. That is the FSL report, Lordship. It is the case of the prosecution, Lordship, that the samples were produced before the court, the magistrate's court, and 10 samples were drawn, Lordship. Now in page 120, Lordship.
120.
It is the case of the prosecution that.
What is this 120?
The FSL report, Forensic Science Laboratory report, chemical test report, Lordship.
Yes.
Now, Lordship, here, this is dated 16 March 2022. However, in the body of the report, Lordship, I want to raise two issues on this, Lordship. The first issue is on the first line itself, Lordship. Refer your memo number, so-and-so, dated 4/1/2022, Lordship. This date is relevant. When the arrest and seizure was made on 19/1/2022, unless the police can time travel, Lordship, this test, Lordship, it does not pertain to my case. 15 days prior, Lordship, to my arrest and seizure, the FSL samples have been obtained, which is impossible, Lordship. Secondly, Lordship,
this was pointed to the trial court.
No, Lordship. Unfortunately, Lordship, this issue was completely missed out by the trial court, Lordship, as well as the council failed to point this out, Lordship. And Lordship, since this is the first appeal, Lordship.
Yes, you can raise it.
Yes, my lord, my lord. Lordship, now the result of the examination. The last line, Lordship.
Yes.
Yes, this is Lordship. Here, I believe a principal question of law will come, Lordship. The exhibits marked C so and so on test were found to be cannabis under bracket ganja, Lordship. Ganja. Under the NDPS Act, Lordship, it excludes fruiting and flowering tops, Lordship.
No, it includes.
Yes, when it is yes, Lordship, it includes, Lordship.
Yes.
Now, when it is not accompanied, Lordship, by the flowering and fruiting tops, Lordship, then it is not ganja. That is what the definition says, Lordship. Now, the description must state, Lordship, whether it is accompanied by fruiting tops or flowering tops, Lordship, of the cannabis plant. Lordship is well aware that in India, Lordship, maybe perhaps not in Northeast, but in India, in many states, we have a culture of consuming bhang, which is the cannabis plant, Lordship. Which is why, Lordship, prior to independence also, several attempts were made by the Britishers, Lordship, to criminalize the consumption of ganja, but it was opposed by the Indian society. And Lordship, in 1961, Lordship,
Non-prohibition.
the present definition, Lordship, as is contained under the NDPS Act, was after much opposition, Lordship, by the Indian delegation, was accepted, Lordship. Because Indians have a culture and religious practices, Lordship, which involves the use of bhang, Lordship. So, whether in this description, Lordship, the samples, Lordship, was accompanied, had fruiting tops or flowering tops, it ought to have been mentioned, Lordship.
No, but when the results of examination shows that the sample was found to be of cannabis ganja.
Yes, Lordship.
So it may be presumed that.
Lordship, but that is the important thing, Lordship. We cannot make presumptions. Lordship.
No, have you cross-examined the forensic expert?
No,
on
Lordship,
that
because Lordship, he was not summoned to the court, Lordship. The chemical examiner was not summoned to the court, Lordship. And Lordship, on this issue, there are several judgments passed by the other high courts, Lordship.
No, but first of all, what is your point?
My point is, Lordship, the chemical test, Lordship, this FSL test, this is bad in law, this cannot be relied upon because why? Because how it should have been, Lordship, that firstly, whether flowering tops or fruiting tops was present, Lordship, that should have been reflected, Lordship. One. Secondly, the amount of the chemical tetrahydrocannabinol, Lordship, which is 25% in ganja, 25% and above in ganja, Lordship, it should be reflected.
For that, you
yes, I have
should have cross-examined the.
Yes, Lordship. But that person, Lordship, was never summoned to the court, Lordship. Now, when I never got the opportunity for cross-exam, if he was summoned to the court, Lordship, I would have.
Who exhibited this FSL report?
The IO, probably, Lordship, the IO.
So you could have cross-examined the IO itself on these points.
Yes, Lordship. Now, Lordship, whether that cross-examination is present or not, Lordship, that is one issue, Lordship. However, Lordship, the legal ingredients, Lordship, the legal requirements, it must be satisfied. If that is not satisfied, Lordship,
Now, is it necessary for the FSL expert to mention it in the report itself? That
Yes,
the
Lordship.
sample
Yes, Lordship.
consists of
Yes.
flowering and fruiting tops, therefore it is ganja.
yes, Lordship, and or Lordship, or the amount of tetrahydrocannabinol, Lordship, which is 25% and above for ganja, and for bang it is 15%. It should be reflected. That is what the courts have consistently held, Lordship. If I may be allowed.
Tetra,
Lordship, it is reflected in the judgment I am about to place, Lordship.
what is the citation?
Lordship, this is a decision passed by the Madhya Pradesh High Court, Lordship, in miscellaneous criminal case number 7965 of 2011. The order is dated 4th of March 2024, Lordship. I'll be placing other judgments also, Lordship, on similar lines passed by other high courts. Nine, Lordship, paragraph 9, my lord.
Yes.
The alleged contraband recovered from the petitioner's finds placed at serial number 55 of the table, wherein 1,000 grams would fall under small quantity and commercial quantity starts from 20 kgs onwards. After filing of the charge sheet, so, the ingredients of the FSL report cannot be improved. The FSL report is discrepant with regard to presence of tetrahydrocannabinol in any manner.
No, where is the proposition that this
The-
tetrahydrocannabinol should be present
Yes,
to the
Lordship.
extent of more
The-
than 25%?
Yeah, the very next line, Lordship. The sample stuff can only be categorized as ganja if percentage of tetrahydrocannabinol is found to be 25%.
On what basis this judgment is saying so? Where is
Lordship,
the authority?
Lordship,
There must be some basis.
yes,
for
Lordship.
court
In
to
one
observe.
decision, Lordship, they have relied on Modi's criminal toxicology, Lordship, which has been consistently accepted by the Supreme Court also, Lordship, and the High Court also.
You show that where in Modi's.
This is also another decision passed by the Madhya Pradesh High Court, Dinesh Rajut versus the Union of India. Page 4, my lord, para 30.
No, you show the Modi's jurisprudence, medical jurisprudence. Whether Modi's jurisprudence is available in library. Yes, please inquire.
All right.
If you are relying on Modi's jurisprudence,
Yes, Lordship.
then you have to show it.
In that case, Lordship, if my lord wants to peruse Modi's jurisprudence,
If you are relying on that,
yes, Lordship, if it can be placed tomorrow, Lordship, I have a copy of it in my chamber, Lordship.
Okay.
Yes.
no, your one case is that 42, that arrest and seizure has been done by an unauthorized
Yes, Lordship.
police personnel.
Yes.
So
Secondly,
it is vitiated.
yes. Secondly, the
FSL
FSL
report is defective
yes, it is defective. It is defective.
because it does not mention the presence of flowering and fruiting top.
Yes. And
It
secondly,
also does not mention that tetrahydro
cannabinol.
cannabinol
Yes,
was
percentage.
not present
Yes,
more
Lordship.
than 25%.
Yes. Lordship,
Then
and-
you have to convince this court that this much of
Cannabinol.
cannabinol is required to be present
Lordship.
for a substance to be
Yes,
regarded as cannabis.
Yes, Lord.
Where is that authority?
Yes, Lordship, and Lordship. Thirdly, Lordship, this FSL report, it does not pertain to my case. Because
Oh,
the-
yes,
Lordship,
yes.
this is, Lordship, very much important, Lordship.
This is a fair,
Yes,
this may cost you. And I'll come to you, but this is appears to be fatal.
You continue reading the sentence that page 20.
Pertaining to police station case.
Yes, same police station case number.
No, but how can you send something? How many days ago? About 15 days prior to seizure. How can you send something?
Maybe just at the typographical error, Lordship, as far as this is concerned.
But that evidence has to be there.
Because section are same, police case number is same. Pretty the same. Lordship.
One aspect is that the punishment is a harsh punishment of 10 years.
yes, Lordship.
10 years.
Yes, 10 years, 10 years.
So everything has to be perfect. So, Mr. Senti Anger,
Yes, Lordship.
are you proceeding or you will come with Modi?
Yes, Lordship. And Lordship, if I may be allowed to submit on the other grounds, Lordship.
Yes, yes.
Lordship, now if I may take my lord to the deposition, Lordship, on the,
No, just a minute.
Yes,
Which judgment you relied where this 25% is mentioned? Madhya Pradesh High Court.
yes, Lordship.
Which judgment citation?
There is no citation for this, Lordship. However, it is the case number.
And name of the parties?
Name of the parties is Tayaram Singh. Tayaram Singh.
Tayaram Singh,
Yes, the last name is Singh. And another,
MP. And one more MP judgment?
and versus state of Madhya Pradesh. And
Yes.
Lordship, the other one is Dinesh Rajot versus Union of India. Criminal appeal number 544 of.
This is also of Madhya Pradesh.
Yes, Lordship.
Okay, okay.
And there is another petition, Lordship, passed by the Karnataka High Court, Lordship. On the same line. Lordship.
Same line.
Yes, Lordship. Abdul Alim versus the intelligence officer.
You will furnish the copy of the same to me.
My lord, my lord.
Okay.
I have mentioned the relevant paragraphs. You have
This
entered.
is only also on this.
Yes, Lordship. Yes,
Tetrahydrocannabinol.
yes, Lordship. Lordship. Lordship, now the Malkana register, Lordship, where the seized contraband was kept, Lordship. It was not produced. If my lord will kindly go to page 138, Lordship, the position of the PW2. Or we can start from PW1's deposition, Lordship. Starting from page 135, Lordship, of the paper book.
Yes. Yes.
Now, Lordship, in cross-examination.
Yes.
It is correct to state that there is no mark or seal, the last third statement, Lordship, in cross-examination in page 136 of PW1. It is correct to state that there is no
Page
mark or
135.
36. It
36.
starts from 135, his depositions, and ends at page 136, PW1. So the last third statement in page 136.
Last statement.
Last third.
Third.
Yes, Lordship. From the bottom, it is correct to state that there is no mark or seal on the seized ganja produced before the court today.
What do you want to say?
Seal must be present, Lordship, on the samples as well as on the, because, Lordship, the samples are found and the remaining substances are kept in the custody of the police, Lordship. There also, Lordship, the seal and packaging number must be mentioned, Lordship. A specific question has been put, Lordship, to the officer in charge during cross-examination, and he is saying that there is no
What
seal.
was produced before the court? Which ganja was produced? It was not destroyed.
No, Lordship. It appears that it was produced, Lordship. From the, because they are saying that before the court today. And Lordship, there are also decided cases which says that, Lordship, the seized contraband in NDPS Act, it must be produced, Lordship.
Of the seized contraband is sufficient.
Lordship. But, Lordship,
the contraband has to be destroyed as early as possible. Keeping samples.
Lordship.
Under 52A.
Lordship. But despite that, Lordship, at that relevant point of time, Lordship, it was produced, Lordship. And they are saying that there is no mark or seal, Lordship, on the seized ganja.
Which shows what?
It shows that it was not properly kept, Lordship. It shows that, Lordship, the samples, Lordship, and the ganja that was produced before the court, there may be no relation. There is no linkage, Lordship, between those two. Because it has to be proved that the samples, Lordship, is from the items produced.
How to prove that?
By, Lordship, making proper seal, packaging number, Lordship.
Now the inventory and certificate of the magistrate under section 52A.
Lordship.
Because this is a case of 2022.
Yes, Lordship.
So that certificate is sufficient to prove whether that certificate was exhibited in this case.
Yes, certificate was exhibited. Certificate is also annexed as part of the criminal appeal, Lordship.
Then ganja need not to be exhibited.
There are also other statements, Lordship, by other witnesses, which clearly shows that, Lordship, there is no proper seal and packaging, and the packages were all torn, Lordship. And, Lordship, the Malkana register, Lordship, it was also not produced before the court.
Malkana register was not produced. So what you intend to submit? What it implies?
It implies, Lordship, that the ganja which was produced before the court that day, Lordship, and the samples that were drawn, Lordship, it does not pertain to me, Lordship. And Lordship, the FSL report, the date that is mentioned in the report, it itself shows, Lordship, that it does not belong to me, Lordship. Because, Lordship, the FSL report and the seized contraband, Lordship, it must relate.
Really. So you want to
There is
say
no
that-
relation.
Say that the chain of custody of the contraband
Yes, Lordship.
has not been maintained.
Yes, Lordship.
So prosecution has failed to show that the sample was of the seized ganja. The test, FSL test was done in respect of the seized sample which was drawn from the seized ganja. That the prosecution has unable to show.
Yes, Lordship.
Okay.
Lordship. Now, Lordship, in a division bench decision passed by this honorable court,
What is the name of the appellant? Name of the appellant
in the
in
division
this,
bench,
this appeal?
Fonni Koza,
Only
Koza,
PH.
PFONYI. Yes, YI. And then Koza is the last name, KOZA.
Okay. He's the driver of this vehicle or what?
Yes, he's the driver,
of the
Lordship.
vehicle
Yes.
from where
Driver,
the
Lordship,
contraband
yes.
was.
The vehicle was unregistered, Lordship, and I'll come to that, Lordship. The question of unconscious possession can also be raised from the facts and circumstances of the case, Lordship. If I may be kindly allowed to place, Lordship, a decision passed by the Honorable Division Bench, Lordship, of this court, reported in 2010 3 GLD,
2010
3 GLD 361. I am relying on paragraph 24.
There are 24.
Yes, Lordship. I may be allowed to read, Lordship.
Yes.
This deals with two issues, Lordship. One, it deals with the issue of description, the issue which I have raised in the FSL report, Lordship. I may be allowed to read, Lordship.
Yes.
It is already found that the seized ganja, including the sample packets, were not sealed and kept in the custody of the officer in charge of the concerned police station, and no application was made before the magistrate under section 52A(2) for certifying the correctness of the inventory and allowing to throw representative samples of such drugs of the seized articles substance in presence of the magistrate and certifying the correctness of the list of samples drawn. The possibilities of tampering with the sample packets could not be ruled out. Lordship, now they start to deal with another issue, Lordship. There was no description about the quality of the seized ganja as per the inventory. And as such, it could not be ascertained whether any flowering or fruiting tops of the cannabis plant were found from the aforesaid 92 packets of ganja seized from the vehicle. So here also, Lordship, on the ground that there is no description whether there is flowering or fruiting tops, the conviction was set aside. Also, the issue of not having the items not having seal has also been raised in this case, Lordship.
Which is the relevant paragraph?
Paragraph 24, Lordship.
In 24, it's.
Yes, the first line itself, it is already found that the seized kancha, including the sample packets, were not sealed and kept in the custody of the officer in charge.
So the possibility of tampering cannot be ruled out.
Yes, Lordship.
That is one.
Yes, Lordship. My
Okay.
lord, my lord, my lord. They have not produced the Malkana register also, Lordship.
Okay.
Now that has already been well discussed in Nuraka's case also, Lordship. That famous Nuraka versus State of Punjab, Lordship, 2008 16 SCC 416.
2016.
2008 16 SCC 416.
Malkana register.
Yes, Lordship.
Which para?
Para 99, 100, 107. In state of Rajasthan versus Tara Singh as well, Lordship, similar issue was discussed in 2011, 11 SCC 559 at paragraph 2.
2011.
Paragraph 71, I'm sorry. Para 2, I'm sorry. Para
2011, 11 SCC
559.
559.
Yes, para 2. Para 2.
What it says in para 2?
Lordship, I don't have a copy of that.
It relates to
Malkana register not been produced before the court. And that, on that ground, Lordship, the conviction was set aside. Now, Lordship, my lord is well aware that during examination, Lordship, under 313, whether it be under the NDPS, POCSO, or regular offenses under the IPC, Lordship, all incriminating circumstances must be put to the accused distinctly, separately, and categorically, Lordship. Now, here, Lordship, no such examination. And if the prosecution fails to do so, Lordship, those portions which the prosecution has left out, it cannot be relied, Lordship. It has to be eschewed from consideration. Now, in page 146 of the paper book, Lordship, only 8 questions were asked, Lordship. Now, Lordship, circumstances were put to the accused or not, Lordship. On 19/1/2022, Lordship, here also the date is clearly reflected. At around 16 hours, you were driving a Maruti Gypsy white and was intercepted at Rajapi Welcome Gate. Is it true? That is question number 1. Question number 2 is, where were you proceeding to? Question number 3, is the vehicle suspected contraband kancha of 360 kilograms approx was seized? What do you have to say? Question number 4, are you aware that Gypsy is unregistered? Question number 5, Lordship, what is your occupation? Question number 6, did you notice that the goods suspected contraband kancha which you were carrying in the Gypsy was covered with tarpaulin? Were you traveling alone? The next question, or with some other passengers? The next question, the last question, do you have anything to say? Now, This cannot be said to be a proper examination under section 313 of the Criminal Procedure Code, my lord, with all due respect, lordship.
Yes.
Lordship, there are a plethora of decisions on this issue, lordship. Only one, lordship. Yes. 2007 3 GLD, lordship. 786, lordship. Relevant para is paragraph 21 and 22. This is a state of Nagaland case, lordship. A judgment passed by my Lord Justice I.A. Ansari. I may be allowed to read paragraphs 21 and 22, lordship. Section 313 CRPC.
Yes.
Aims at enabling the accused to personally explain circumstances appearing in the evidence against him. Examination of an accused under section 313 1B CRPC is therefore not an empty formality but a solemn act of every trial court. 22, as observed by the apex court instead of Maharashtra versus Sukhdev Singh. Section 313 CRPC is the statutory provision which embodies the fundamental principle of a fair trial based on the maxim audi alteram partem, and that attention of the accused must be specifically invited to inculpatory pieces of evidence or circumstances laid on record with a view to giving the accused an opportunity to offer his explanation if he chooses to do so. As a matter of fact, as indicated in Sukhdev Singh, Supra 3131 PCRPC does not only cast a solemn duty on the trial court to elicit the response of the accused to every piece of incriminating circumstances which may appear against him, but also confers a corresponding right on the accused to receive an opportunity so that he can offer his explanation, if he has any, with regard to such incriminating materials or circumstances as may be appearing against him from the evidence on record. Examination of the accused under section 3131P CRPC is reached after the witnesses of the prosecution have been examined and before the accused is called on to enter upon his defense. At the stage of closure of prosecution's lordship.
Yes. Please read.
At the stage of closure.
At the stage of closure.
Of prosecution's evidence and before statement of the accused under section 3131P CRPC, the trial judge is not expected to evaluate the evidence for the purpose of deciding whether or not he should question the accused. Before an accused is examined under section 3131P CRPC, the trial judge is not expected to sift the evidence and pronounce whether or not he would accept the evidence regarding any incriminating material against the accused to determine whether or not he would examine the accused on that material. To do so, points out the apex court in Sukhdev Singh so-and-so would amount to prejudicing the evidence without hearing the prosecution under section 314 CRPC. No wonder, therefore, the Supreme Court in Sukhdev Singh has observed that however weak or scanty the prosecution evidence may be with regard to an incriminating material, it is the duty of the court to examine the accused and seek his explanation thereto. It is only after that stage is over that the oral arguments have to be heard before the judgment is rendered. It is only where the court finds that no incriminating material has surfaced that the accused may not be examined under section 313. In short, if there is material against the accused, he must be examined under section 313 1P CRPC. In fact, it is apposite to point out at this stage that in Sharat Birdi Chand Sarda versus State of Maharashtra, the apex court made it clear that the circumstances which were not put to the accused while he was examined under section 313 CRPC, such circumstances have to be kept excluded from the court's considering at the time of determining the guilt or otherwise of the accused. Impugned order. judgment and order, Lordship. It is not sustainable in the eye of law, Lordship. And my Lord may kindly set aside, Lordship. And Lordship, the more than 4 years, Lordship. 4 years, 2 months. He has been under custody, Lordship. Deeply obliged, Lordship.
Modi,
Lordship, I may be allowed to place it tomorrow, Lordship. Because it's a thick book, Lordship, and
but you have cited a judgment of Madhya Pradesh
yes, Lordship.
where the mention about Modi is there.
Yes, Lordship.
That what is the percentage of
Yes, Lordship. In fact, Lordship, on a closer look, it is Parikh's paragraph 30, Lordship.
it is not Modi's.
Yes, Lordship.
No, Modi's medical jurisprudence has been accepted as an authority,
Yes, Lordship. Lordship.
but others
Yes, Lordship.
may be
Yes. It is-
questionable.
Yes, Lordship. I agree, Lordship. But Lordship, despite that, Lordship, there are already decided cases, Lordship. A plethora of judgments, Lordship, across the country, passed by different high courts on similar lines. Regarding the percentage of tetrahydrocannabinol. And Lordship, there is also that division bench decision in 2010 GLD, which I have placed, Lordship, wherein it says that, Lordship,
No, whether it is ganja
yes,
or
Lordship.
some other preparation of cannabis,
Yes, Lordship.
because ganja can be physically tested. Physically, it can be found that whether fruiting top,
Lordship,
flowering
Lordship.
and
Yes,
fruiting
Lordship.
tops are
Yes,
there.
Lordship. But that
So for ganja, that chemical test may not be necessary.
yes, Lordship. But
For other preparations like charas,
yes, Lordship.
hashish,
Yes, Lordship.
this
It is-
tetrahydrocannabinol may
It is
be,
more than 40% in those.
for that chemical test may be required.
Yes, Lordship.
But for ganja, even from physical observation by
Yes.
it
Yes.
can be ascertained by the forensic
Yes, Lordship.
expert.
Yes, I agree, Lordship. But Lordship, that description is not there. If that description was there, Lordship,
No, but report says that
it is ganja,
it is
Lordship.
ganja.
Yes, Lordship. But
And there
clearly
is a-
saying that it is ganja will not suffice. That is my humble submission.
and you
before
were
this
not
honorable court.
afforded the opportunity to cross-examine the
Yes.
FSL
Yes, the
expert.
chemical examiner, Lordship.
Okay.
On that, Lordship, Lordship, regarding the Malkana production of the Malkana register, Lordship, I may be allowed to place this judgment. I won't be reading this out, Lordship.
You have already.
Yes,
for
Lordship, but instead
Malkana-
of those, Lordship, I believe this 2024 decision will be
2024,
24. The
2000
citation, Lordship.
2020.
2000. Yes.
The SCR
2024 3 SCR 23
Tera,
21, Lordship.
what it says. Please read it.
Sub-Inspector LW10, who prepared 3 samples of ganja as per the testimony of PW5, was not examined in evidence. In addition thereto, the prosecution neither examined any witness or produced any document to satisfy the court regarding safekeeping of the samples right from the time of the seizure till the same reached the FSL. The official who collected the samples from the police station and carried the same to the FSL was not examined at the trial. From the quoted portion of the evidence of seizure officer, Inspector PW1, it is clear as daylight that he handed over one of the 3 samples to the accused. The witness also admitted that he could not mention any sealing of the samples in the Panchanama. Contrary to the evidence of PW1, PW5 stated that 3 samples of ganja were taken out by Sub-Inspector LW10 and were handed over to the witnesses who forwarded the same to the SCP for sending it to the FSL. In cross-examination, the witness admitted that he did not file any document to show the property was kept in Malkana. The Malkana register was not produced in the court. The FSL report does not disclose about the punch sheets and seals and signature of the accused on samples. The property deposited in the court Mutamal was not having any official seals. The witness also admitted that he did not take any permission from the court for changing the original 3 packets of Mutamal Kancha to 7 new packs for safe keeping. These clearing loopholes in the prosecution case give rise to an inescapable inference that the prosecution has miserably failed to prove the required link evidence to satisfy the court regarding the safe custody of the sample packets from the time of the seizure till the same reached the FSL. Rather, the very possibility of 3 samples being sent to the FSL is negated by the fact that the seizure officer handed over 1 of the 3 collected samples to the accused. Thus, there remained only 2 samples, whereas 3 samples reached the FSL. This discrepancy completely shatters the prosecution case.
No, this is a fact situation. We are on principles.
Yes, Lordship.
What ratio is there?
Yes, Lordship, here also, Lordship, but here also, the fundamental question remains that the Malkana register was not produced. It's the same as in our case, Lordship. The register was never produced before the trial court, Lordship. In order to satisfy the court that the samples were safely kept.
No, but where is the observation that to show that there was chain of custody of the contraband was maintained, to show that it is necessary to produce the Malkana register?
There are, Lordship, a plethora of decisions on that, Lordship.
No, you show me one decision where it is.
Lordship, in that case, Lordship, along with the Modi's book,
where it is specifically mentioned that if the prosecution fails to exhibit the Malkana register, it can be presumed that, or it can be held that they have failed to
yes, Lordship.
Show the proper chain of custody.
Lordship, in other FSL tests, Lordship, of course, this is heroin, Lordship, but the chemical percentage.
No, this is not applicable to your case.
Yes, Lordship. But Lordship, the chemical percentage here is also given as 56.93, Lordship. Likewise, Lordship, in ganja, the presence of tetrahydrocannabinol must be specified, Lordship.
Specified.
And Lordship.
No, if it has to be specified, if it is other preparations of cannabis like hashish, charak, resin of ganja.
Lordship.
But it is only the flowering. If it is flowering and fruiting top of cannabis, then it can be held that it is ganja.
Yes, Lordship. Now, Lordship, that is not present, Lordship, in the description of articles, Lordship. Neither in the result, Lordship. And Lordship, in the seizure memo also, Lordship, which I have already taken my lord to it at page 108 of the paper book. There is no description as such that it contains flowering and fruiting tops of the cannabis plant. And without that, Lordship, it may be something else, Lordship. Not ganja. Or it may not even be cannabis plant, Lordship. Assuming it is cannabis plant, it may be bhang, Lordship. And possession of bhang is not a punishable offense, Lordship.
No, for that, you had to cross-examine the FSL expert.
Yes, Lordship. But yes, Lordship.
That
yes,
he
Lordship.
Failed to distinguish between bhang and ganja.
Yes, Lordship. That opportunity was not given to us, Lordship, because the chemical examiner was
Whether you
never-
raised this plea before the trial court.
Lordship, the chemical examiner can only be summoned by the court, Lordship.
But you can raise this plea before the trial court matter.
Yes,
You
Lordship.
need to
Lordship,
cross-examine.
Lordship.
And then if it was not afforded to you,
Yes,
then
Lordship.
the question is different.
Yes, Lordship. But Lordship, the court for examination of experts, Lordship, mostly Lordship, it is the discretion of the court, Lordship. And if the court, after considering the case, in their wisdom, thinks fit that the chemical
CRPC.
the deposition is essential.
Please give me CRPC.
Because Lordship, not only here, but fingerprint experts, handwriting experts, all these are being relied on from time to time by the prosecution, Lordship.
Read 293. CRPC.
Lordship. Yes.
Court may accept the report of a scientific officer
Yes, Lordship.
even without summoning him.
Yes, Lordship. Lordship.
It may summon him, it may not summon
Yes,
him.
Lordship.
So if you think that you are prejudiced,
Yes.
whether it was for you to request summoning of the FSL expert.
Yes, Lordship. I believe, Lordship, the court should have summoned the scientific expert in this instant case, Lordship.
Okay. Yes, Mr.
But because of his non-summoning, I have been prejudiced, Lordship.
Yes, Mr. Anything else?
On Lordship, I wanted to submit on conscious and unconscious position also, Lordship. However, Lordship, I believe that, Lordship, the submissions that I have made, Lordship, unless my friend.
No, you make your submission. You will not be given again chance. You can only reply to.
Lordship.
You cannot raise a new argument after he.
Lordship, now.
Make within 5 minutes
Yes.
before lunch.
All right, Lordship. The suspected item, Lordship. It was already packed. The items were already covered, which is why, Lordship, when.
Okay, one query. Whether the search was made by the UBC, that
Yes,
constable,
Lordship.
on the basis of some secret information or during regular Naka checking. What 100 says? Or whether he was authorized.
Lordship, there's nothing in the prosecution's case which says that, Lordship, there was some secret information.
So it was during regular Naka checking.
Yes, Lordship.
So suppose in regular Naka checking, a constable finds a person carrying contraband, prohibited contraband.
Lordship.
What he would do? He will not arrest him.
He will stop, Lordship, and a gazetted officer, Lordship, or an empowered officer under the NTPS Act shall be called, Lordship, and then the two of them will search, Lordship, if he is suspicious, Lordship.
But suppose before that he fled away.
But, Lordship, it is a theory, Lordship. Here, there is no case of fleeing away, Lordship. I never fled, Lordship. It may occur in some other cases, Lordship, but I cannot speak for those people, Lordship.
It is
During the examination also, Lordship.
upon frisking, contraband was recovered from the vehicle. So it was during regular Naka checking duty.
Lordship.
So from the point when he detected that NDPS
Yes, Lordship.
materials are there,
Yes, Lordship.
42 will come in. He
Yes,
has to
Lordship.
inform the authorized officer.
Lordship.
Now, what is your submission?
Now, Lordship, he should have, if he was suspicious, Lordship, then he should have called empowered officer before checking the vehicle and making arrest, Lordship.
He could not have checked himself.
No, he could not have checked himself, Lordship.
Okay. Because he did
He's
not.
not, yes, he is not an empowered officer, Lordship.
Okay.
In fact, Lordship, in one of the cases passed by this honorable court, Lordship, I don't remember the case number, but the party's name is Iren Izang, Lordship, versus State of Nagaland. On that ground, the FIR was quashed, Lordship, by this honorable court. Justice Nielsen passed the order, passed the judgment, Lordship. Lordship, if we may kindly continue after the break.
Yes. We'll continue after break.
My lord.
We'll not take up the other Mr. Moa Jamir's matter. It may be difficult. We'll adjourn that because it will take time.
Lordship.
Mr. KV Angami will reply. And then he may again make submissions. I have queries.
My lord.
So we will finish this matter today. We'll not take other matters instead of keeping you waiting.
My supplementary hearing that is fixed. It will let it come up tomorrow.
Tomorrow?
Yes. Or Monday.
But we have limited time only.
If you also make any accommodation, because it's a short matter.
No, today it may, I see it difficult. Your item is?
Mine is 26, Lordship.
And Mr. Longchair, your item?
Supplementary fix.
Oh, you have long. What is the matter?
It's extraordinary pension, simple. The petitioner's husband and father, three of them, different cases, but it's short. All of them, they died while performing duty, electrocution. Practically short matter. To Monday.
Okay, we will fix it on Monday. If possible, we'll take it up. Otherwise, item number 41, 42, 43. Due to paucity of time, this matter could not be taken up for hearing today. On request of learned counsel for both the sides, let this matter be listed on 20. Is it okay for government?
No objection. Monday.
On 24th. And Mr. Jamir, you may wait.
No.
If time, your matter is relating to?
Gratuity, Lord.
You are contesting. How much time will it take?
It should not take time because the documents speak so.
So you may wait for 1 hour.
Lord.
Considering their submission, if it finish, then wait for some time after post lunch. We'll try to take it.
Lordship, if I may be allowed to kindly peruse the photo the
Yes,
LCR.
yes, go through it.
Much obliged. Kami itu cuti tahu mencari itu LC ada tu. Kami last time page number not growly power itu itu wala cuti tu. Takang apa tu? Di cuti last day it is part of the record. For 1 2022 tu. Nah itu refer to your memo number dated for 1 2022. That's the one. Ya, jadi buat. Itu one of the rules.
That's a lot of agency.
Nang boleh lah. Some other case, Lordship, not mine.
Which memo is it is referring to?
That we don't have, Lordship.
That please find everything.
Yes.
close
Now
to
again,
16.
Lordship, in that same page, Lordship, 106, Lordship, the very next line.
The
the
date of arrest and
My lord,
okay, it was
date of arrest is 19, Lordship.
19-1.
Yes, my lord, 19/1/2022. Date of arrest and date of seizure is 19/1/2022. Now, Lordship, in the same page, Lordship, page 106, the 10 exhibits are returned herewith, Lordship. That means those 10 samples, Lordship. These 10 exhibits were never produced before the court. Actually, these are produced, Lordship. They are called remnants, Lordship.
Remnants.
They were never produced before the trial court. Now, Lordship, moving on, Lordship. The vehicle, Lordship, he was in need of money, Lordship. So somebody who is known to him, Lordship, it is mentioned in the 313 statement also, Lordship, the name, Lordship. Kako, who is known to him. He told him to transport that gypsy, Lordship, from Manipur to TCP Kohima, Lordship. And then he'll be paid 10,000. Since his wife was pregnant and he was in need of money, Lordship, he accepted. And 10,000 for, it's a good amount, Lordship. And he was unaware of the contents of the items which was covered by the tarpaulin, Lordship. Unfortunately, he was stopped, arrested, the items were seized, and later on it was said that the allegation was that it was ganja, Lordship. However, he was never in conscious possession of those items, Lordship. And my lord is well aware, Lordship, that possession under the NDPS Act is a mental
Is
a mental element,
What is the
Lordship.
normal rate of which a driver gets for driving a vehicle from Manipur to Kohima?
I believe, Lordship, it is reasonable, 10,000. Lordship, because for hiring, Lordship, for hiring even to travel to from one district to, let's say, my district, from Kohima to Mokokchung, the taxis, they charge 9,000, Lordship. I inquired only, I mean, for my personal purpose, Lordship, a week ago, Lordship. So from Kohima to Manipur, Lordship, I believe it will be more, Lordship. And after reaching Kohima, Lordship, he has to, from his, since there is no vehicle, he has to travel back to Imphal from his own pocket, Lordship. So I believe 10,000 is reasonable. If it was 50,000, 1 lakh, then suspicion may be raised, Lordship. Yeah, Lordship, I would like to place After Singh versus State of Punjab, Lordship, 2002. If I may be allowed to kindly place a copy of the decision, Lordship.
Citation is?
Yes. 2002-7419. 2002-7 SCC 419.
What is the page number?
419, Lordship.
No, what is the para?
Lordship, I may be permitted to give a hard copy of the decision that I'm relying on, Lordship, in a short while, Lordship, and then I'll indicate the para, Lordship. I'll hand it over to the court assistant. So on those grounds, Lordship,
Yes, Mr. Anything else? Finish.
my Lord.
Yes, Mr. Angan.
May I please, my lord. Now, as regard the issue of the presence of the officers at the time of arrest, Lordship, that was addressed in paragraph 37 of the 37 of the judgment. But maybe I'll come to it later, but Lordship, that one.
Okay.
After briefly answering what my learned friend has raised. And then again coming back, that is the arrest of presence of the officers at the time of arrest is answered at paragraph 37, compliance of section 42 and 57. Then second point. Now my learned friend has raised about the date in the FSL report that it was and allege that and submit that the case, this is the sample does not belong to them. But Lordship, the date, I think that was at the typing error. Otherwise, the case number is same. If had it been some other cases, if and more, the case number is case number 1/2022. If it is some other numbers before that, there may be a confusion. But every record leads and clearly leads that case along, Lordship. And so as far as the date is concerned, there's I can confidently say that this case is not does not refer to any other cases. And besides, this issue was not raised before the trial court during trial court during trial.
Yes.
And secondly, this is also not in the pleading, Lordship. This is out of pleading, even in the present, even now, Lordship. This is not even the pleadings. And as regards the, my lord has already examined regard the examination of the FSL report, expert, clinical expert. That was not is record does not speak. That record does not speaks that it doesn't. It was not insisted upon by the nor raised by the before the trial court, Lordship. Even this was not raised. And even similarly, even this issue was not in the pleading. This is also out of pleadings, Lordship. And now my learned friend has also raised about the non-production of reproduction of marks not registered.
Yes.
However, this also not raised before trial court, nor this is also raised in the present petition appeal, not in the pleading.
Yes.
And now coming back to that section 313, in that respect, also now, my learned friend has raised about the issue of the questions. But even this issue is not raised before the trial court, neither is it that is there in the pleadings, even this pleading, Lordship. So new grounds are brought in. So new grounds are brought in, which my lord is already aware now. Now,
Yes.
now my in total, my humble submission before this honorable court, there is no infirmity in the judgment and order passed by the special court below. If my lord may kindly have some patience, I may be allowed to read some of the about 20 pages of the judgment. Starting from page 23 of the judgment, okay, page 75. Now here, two issues. Paragraph 24 answers what kind of goods were seized. That was answered. Then two issues were examined, Lordship. That is why I just want to reaffirm what the learned court below has found out, Lordship. I may be allowed to start with paragraph 25, Lordship.
Yes.
Accused one has admitted in his statement recorded under section 313 CRPC that the contraband seized from the vehicle he was driving was ganja. Question 3. I was not aware that the vehicle had contraband ganja of that quantity. He was not aware of only the quantity, otherwise he knew that it was ganja, Lordship. It was Kakho who took the gypsy and put the contraband ganja in the vehicle and told me to take it to Kohima. Report exhibit P4 of the seized samples received from Agil Nika, Assistant Director, Forensic Science Laboratory, Nagaland, has confirmed that contraband was cannabis situated. Thus, I was not required to give a finding on whether the seized contraband was cannabis, ganja, and therefore the contention of learned defense counsel that some plant materials, as mentioned in the FSL report, do not come under the purview of ganja, as they are not flowering or fruiting tops of the cannabis plant is not acceptable, and thereby reject that. And Lordship, here, Evidence Act, Lordship, section 58. My Lord knows, I think I'll read it. Section 58.
Yes.
Section 58. Facts admitted need not be proved. Facts admitted need not be proved. And this is an admitted fact, Lordship. No fact needs to be proved in any proceeding which the parties thereto or their agents agreed to admit at the hearing, or which before the hearing they agreed to admit by any writing under their hands, or by any rule of pleading in force at the time they are deemed to have admitted by their pleadings, provided that the court may in its discretion require the facts admitted to be proved otherwise than by such admissions. So the learned trial court below has come to finding that this is an admitted fact, Lordship. Now, coming back to the judgment, Lordship, paragraph 26, points of determinations. Under these facts and circumstances of the case, the following two questions arrive for determinations: whether the seized contraband ganja weighed 360 kilograms, amounting to commercial quantity. 2. Whether Mr. Poni Koza, the
was found in unlawful possession of seized contraband ganja while transporting to TCB Gate, Kohima.
Yes.
The first requirement for determination of this court is the if the seized ganja is the quantity of the seized ganja, I think. PW2 Kedukro has stated in his cross-examination that there were 36 packets weighing about around 360 kilograms, and weighting of the said contraband ganja was done at police station in his presence, and it was packed in a black in color. PW2 further stated in his cross-examination that at the time of weighing the
It should have been
ganja.
weighing at the time of weighing of the.
Oh, yeah, wait, yes, sorry. Wait, there were two constable, OC and Sekutso, PW4, and another person whose name he cannot remember. The evidence of PW2 Kedukro is corroborated by PW1, PW5, and PW6, as they all have unanimously stated in the cross-examination that the seized contraband ganja was numbering 36 packets, and each packet is weighing approximately 10 kilograms. Even the accused one in his statement under 313 CRPC has not denied. When this court has put a question to him as follows. Question 3. In the seized vehicle, suspected contraband ganja of 360 kilograms approximately was seized. What have we got to say? Answer: I was not aware that the vehicle had contraband ganja of that quality. I think this is quantity. Even otherwise, A1 has no where I denied that the contraband ganja recovered from his gypsy was less than 360 kilograms. No suggestion has been put to these witnesses during their cross-examination by the defense questioning the 360 kilograms of seized contraband ganja. I accordingly hold that the weight of seized contraband ganja was 360 kilograms, which is a commercial quantity. Paragraph 28. Next, whether Mr. Pungi Koza was found in unlawful possession of seized contraband ganja while transporting to TCP Gate, Kohima. According to UBC Kedukro Tero PW2 on 19/1/2022, MVCP was conducted at Razab Gate by the Indian Reserve Police, in short IRP, and he was assigned by the officer in charge Pesero to guide the IRP, and while they were of MVCP duty, one gypsy came and they stopped it. They informed the driver about checking the vehicle, to which the driver agreed. During checking, they found about 360 kilograms of ganja packed in 36 packets, having about 10 kilograms in each packet under the tarpaulin in the vehicle. He also testified that on questioning the driver, he admitted that he was carrying the ganja to Kohima on payment of rupees 10,000 for delivery, though he did not know the owner. Accordingly, he informed to OC PW1 Pesero Kohima, Pesero, who reached the spot and taken the driver along with the gypsy to the Thana. PW2 identified that accused one. PW1 had deposed that on 19/1/2022 around 1750 hours, MVCP was conducted by the IR personnel guide by PW2 at Razaba Gate. He received an information from PW2 that during check-in, one person carrying 36 packets of ganja in one white gypsy unregistered was intercepted. He, along with Thana party, rushed to the spot and formally arrested the accused one and seized the ganja along with gypsy and brought to the police station, Pesero. The driver told him he is from
Manipur side, and he was to deliver the ganja to Kohima, and it will be paid rupees 10,000. He identified the accused one inside the courtroom. PW3 also deposed that on 19/1/2022, he accompanied the OC to Razabad gate on the information that one person along with gypsy and ganja has been intercepted during MVCP. PW6 also stated on the same line with both PWs. There is nothing in the testimony of PW1, PW2, PW3, or PW6 that no proceedings in such manner has taken place or that no contraband was recovered from the vehicle driven by the A1. Learned Defense Counsel has argued that in the charge sheet, IO has stated to have received the sumoto FIR from the complainant at 17 hours, but in the FIR, the complainant has stated that the vehicle was intercepted at 17:50 hours. Then how is it possible that even before the incident, a sumoto could be lodged at the police station? But it is immaterial to note that during the cross-examination of the complainant, PW2 and investigation officer PW6, the defense did not contradict the timing of the receiving the FIR from them. The FIR was marked as Exhibit P1 and charge sheet was marked as P6 during the evidence of PW2 and PW6 respectively. No suggestion has been put to these witnesses that it was a fake case or planted by the PW1, PW2, and PW3 against the accused one. There is absolutely no reason as to why there is no cross-examination regarding the timing of receiving the FIR. Therefore, I find that receiving the FIR at 17 hours might be computer typing mistake or on the part of the complainant, which do not affect the roots of the prosecution case. Be that as it may, it's observed that the FIR is never an encyclopedia, rather it is information made at the first instance, which sets the criminal law into motion. Criminal courts should not be fastidious with mere omission in the first information statements, since such statements cannot be expected to be a chronicle of every detail of what happened, not to contain an exhaustive catalog of events which took place. See so and so, 1997 for SCC 161, paragraph 30. Interestingly, the testimonies of PW1, PW2, PW3, and PW6 has been admitted by accused one in his statement recorded under section 313 CRPC. Accused one has specifically admitted that on 19/1/2022 at around 16 hours, he was driving a Maruti Gypsy white proceeding to Kohima and was intercepted at Razeba welcome gate by the police. According to him, he was not aware that the vehicle had contraband ganja of that quantity. It was Takho who took the gypsy and put the contraband ganja in the vehicle and told him to take it to Kohima. Accused one also reiterated that the goods were covered with black cloth like vehicle mat, and he was driving the gypsy and was traveling.
No, just a minute. Before this, let us once look the 313 statement. At which page it is?
Page 146.
What is the time of interception of the vehicles?
Question number 1, Lordship.
That around 16 hours. You
Yes,
were,
Lordship.
from where the court got this 16 hours? Because in FIR it was mentioned 17 hours. 17 hours FIR mentioned, and the PW6 has stated
Yes, at around 17, 50 hours FR safe. page 100.
No, IO has stated that he receives suo motu FIR. IO's testimony says that pay 17 hours.
Yes.
IO is PW.
Uh, PW6, Lordship.
PW6.
Yes.
Just a minute, let us go through his testimony. Okay, he stated 16 hours.
PW1, who is the OC to whom the FIR is addressed to, he is saying 1750 hours in his examination in chief. Whereas the IO in his examination in chief, he has stated 16 hours.
So while putting questions to the accused under 313, the court picked only 16 hours. PW6 testimony. How court came to finding that it was 16 hours, that PW6 was telling truth and PW1 is wrong. Because there are 3 timings. In FIR, it is mentioned as 1750. PW1 says 17. PW6 says 16. And court puts up question only 16. On what basis court decided that 16 is the correct time before assessing the evidence? Because 3 timings of the seizure of the interception of the vehicle was there before the court when 313 examination was held. But court it did not refer to which witness stated it to be 16 hours. The manner in which questions were put by the trial court does not appear to be appropriate. Proper. Okay, proceed.
So situation thus. Situation thus, it is clear that on 19/1/2022 at around 1750 hours, accused was alone found in possession of a huge quantity of contraband loaded in his white Merc Gypsy unregistered at Razabab Gate by the police official.
And what is the basis of this conclusion? That again he is saying that at 1750 hours he was found in possession. How court came, on what basis it is? 1750 hours has been mentioned in the FIR. PW1 says 17 hours. PW6 says 14 hours. Question was put 14 hours. The court is concluding that it is 1750 hours. Okay. Because this is the conclusion of the court. Situated thus, it is clear that on so and so date at around 1750 hours. That is the time mentioned in the FIR. That which is relied upon by the court. Why court is this? Because time is important. They have raised the plea of time and date. Okay, proceed.
Accused one has not able to state anything credible in his statement under section 313 CRPC why he is falsely implicated in the present case. It is also not a case that he had not come to Razabad Gate on 19/1/2022 on his white Gypsy unregistered, alone loaded with contraband ganja, about 360 kilograms going to TCP Gate, Kohima. Once there is recovery of contraband
from the accused, then there is presumption under Section 35 and 54 NDPS Act against the accused and onus upon accused to rebut the said presumption. PW6 Sale Luchakehe, the investigating officer, has been thoroughly cross-examined by the learned defense counsel for the AI. According to him, the contraband ganja was found in the vehicle driven by the accused one, and during his body search, nothing was seized, recovered, and he was traveling all alone. PW6 further stated that no information was provided by the accused one with regard to the name and address of the owner of the vehicle, nor the seizure of the contraband ganja, and there was no clue about the involvement of any other person, as accused one has failed to provide the same. Accused one, during his statement under Section 313, CRPC has not given the particulars of so-called Kakho who loaded the contraband ganja in his white gypsy unregistered at Shiraf village area under Manipur State on 19/1/2022. Accused one remained evasive over the identity of Mr. Kakho. The concealment of particulars of Kakho identity address remain raised adverse inference against the accused one, and it can be inferred that the accused one is deliberately not disclosing Kakho's identity, and thus the culpable mental state is to be presumed against him. Situated thus, the prosecution has been able to establish that on the night of 19/1/2022, accused one was alone, found in possession of such a huge quantity of contraband ganja loaded in an unregistered vehicle, driven by him while conducting MVC at Razaba Gate Visero by the police officials. Presumption under Section 35 and 54 of the NDPS Act. It is settled law that once the possession is established, the person who claims that it was not a conscious possession or have no knowledge of concealment has to establish it. Section 35 of the Act gives statutory recognition of this proposition because of the presumption available in law. Similar is the position in terms of Section 54, where also presumption is also be drawn from the possession of illicit articles. It is for the accused to prove that he has no knowledge or not in conscious possession of contraband. Apex Court in Mohan Lal versus State of Rajasthan, criminal Senso, dated Senso, reported in 2015, 6 SCC 222 dealt this aspect in detail and held as under. Coming to the context of Section 18 of the NDPS Act, it would have a reference to the concept of conscious possession. The legislature, while enacting the said law, was absolutely aware of the said element, and that the word possession refers to a mental state as is noticeable from the language employed in Section 35 of the NDPS Act. The said provision reads as follows. 35. Presumption of culpable mental state. 1. In any prosecution for an offense under this Act, which requires a culpable mental state of the accused, the court shall presume the existence of such mental state, but it shall be a defense for the accused to prove that fact that he had no such mental state with respect to the act charged as an offense in that prosecution. Explanation. In this section, culpable mental state includes intention, motive, knowledge of a fact, and belief in, or reason to believe a fact. For the purpose of this section, a fact is said to be proved only when the court believes it to exist beyond a reasonable doubt, and not merely when its existence is established by a preponderance of probability. Paragraph 34. On a perusal of the aforesaid provision, it is cogently clear that it includes knowledge of a fact, that apart Section 35 raises presumption as to knowledge and culpable mental state from the possession of illicit articles. The expression possess or possess is used in connection with the statutory offenses of being in possession, prohibited drugs and contraband substances. Conscious or mental state of possession is necessary, and that is the reason for enacting Section 35 of the NDPS Act. In Noor Agra versus State of Punjab and another part of 17, the court noted Section 35 of the NDPS Act, which provides for presumption of culpable mental state, and further noted that it also provides that the accused may prove that he had no such mental state with respect to the act charged as an offense under the prosecution. The court also referred to Section 54 of the NDPS Act, which places the burden to prove on the accused as regards possession of the contraband articles on account of the same satisfactorily. Dealing with the constitutional validity of Section 35 and 54 of the NDPS Act, the court ruled thus the provision of Section 35 of the Act, as also Section 54, therefore, in view of the decision of this court, therefore cannot be said to be ex officio unconstitutional. We would therefore, however, keeping in view the principles noticed herein before, examine the effect thereof vis-a-vis the question as to whether the prosecution has been able to discharge its burden hereinafter, and thereafter proceeded to state that Section 35 and 54 of the Act no doubt raises presumption with regard to the culpable mental state on the part of the accused, and also place the burden of proof in this behalf on the accused, but a bare perusal of the said provision would clearly show that presumption would operate in the trial of the accused only in the event the circumstances contained therein are fully satisfied. An initial burden exists upon the prosecution, and only when it stands satisfied with the legal burden achieved. Even then, the standard of proof required for the accused to prove his innocence is not as high as that of the prosecution. Whereas the standard of proof required to prove the guilt of the accused on the prosecution is beyond all reasonable doubt, but it is preponderance of probability on the accused. If the prosecution fails to prove the foundational facts so as to attract the rigors of Section 35 of the Act, the actus reus, which is possession of contraband by the accused, cannot be said to have been established. With a view to bring within its purview the requirements of Section 54 of the Act, element of possession of the contraband was essential so as to shift the burden on the accused. The provisions being exception to the general rule, the generality thereof would continue to be operative, namely the element of possession will have to be proved beyond reasonable doubt. In Bola Singh versus State of Punjab, the court, after referring to the pronouncement of Noor Agra, concurred with the observation that only after the prosecution has discharged the initial burden to prove the foundational facts, then only Section 34 would come into play. While dislodging the conviction, the court stated that it is apparent that the initial burden to prove that the appellant had the knowledge that the vehicle he owned was being used for transporting narcotics still lay on the prosecution, as would be clear from the word knowingly, and it was only after the evidence proved beyond reasonable doubt that he had the knowledge would the presumption under Section 35 arise. Under Section 35 also presupposes that the culpable mental state of an accused has to be proved as a fact beyond reasonable doubt, and not merely when its existence is established by a preponderance of probabilities. We are of the opinion that in the absence of any evidence with regard to the mental state of the appellant, no presumption under Section 35 can be drawn. The only evidence which the prosecution seeks to rely on is the appellant's conduct in giving his residential address in Rajasthan, although he was a resident of Fatehpur in Haryana, while registering the offending truck, cannot by any stretch of imagination fasten him with the knowledge of its misuse by the drivers and others. Having noted the approach in the aforesaid two cases, we may take note of the decision in the Rampal Singh versus State of Punjab. when the court was referring to the expression possession in the context of Section 18 of the NDPS Act. In the said case, opinion was found in the dicky of the car when the appellant was driving himself, and the contention was canvassed that the said act would not establish conscious possession. In support of the said submission, reliance was placed on Avatar Singh versus State of Punjab and Sorak Khan Gat Khan Pathan versus State of Gujarat. The court, repelling the argument, opined thus: we do not find any substance in this submission of the learned counsel. The appellant Dharanpal Singh was found driving the car, whereas appellant Major Singh was traveling with him, and from the dicky of the car, 65 kg of opium was recovered. The vehicle driven by the appellant Dharanpal Singh and occupied by the appellant Major Singh is not a public transport vehicle. It is tried that to bring the offense within the mischief of Section 18 of the Act, possession has to be conscious possession. The initial burden of proof of possession lies on the prosecution, and once it is discharged, legal burden will shift on the accused. Standard of proof expected from the prosecution is to prove possession beyond all reasonable doubt, but what is required to prove innocence by the accused would be preponderance of probability. Once the plea of the accused is found probable, discharge of burden, initial burden by the prosecution will not nail him with offense. Offenses under the Act being more serious in nature, higher degree of proof is required to convict an accused. It needs no emphasis that expression possession is not capable of precise and completely logical definition of universal application in the context of all the statutes. Possession is a polymorphous word and cannot be uniformly applied. It assumes different color in different contexts. In the context of Section 18 of the Act, once possession is established, the accused who claims that it was not a conscious possession has to establish it because it is within his knowledge. From a plain reading of this aforesaid, it is evident that it creates a legal fiction and presumes the person in the possession of illicit article to have committed the offense in case he fails to account for the possession satisfactorily. Possession is a mental state, and Section 35 of the Act gives statutory recognition to culpable mental state. It includes knowledge of fact. The possession therefore has to be understood in the context thereof, and when tested on this anvil, we find that the appellants have not been able to satisfactorily account for the possessions of opium. Once possession is established, the court can presume that the accused had culpable mental state and have committed the offense. In somewhat similar fact, this court had the occasion to consider the question in Mandalal versus State of Himachal Pradesh, wherein it has been held as follows. Once possession is established, the person who claims that it was not a conscious possession has to establish it because how he came to be in possession is within his knowledge. Section 35 of the Act gives a statutory recognition of this position because of the presumption available in the Act. Similar is the position in terms of Section 35, where also presumption is available to be drawn from possession of illicit articles. In the factual scenario of the present case, not only possession but conscious possession has been established. It has been shown by the accused appellants that the possession was not conscious in the logical background of Section 35 and 54 of the Act, paragraph 35. In view of the mandate of above judgment, Section 35 raises a presumption as to the knowledge and culpable mental state on the possession of illicit articles. As discussed, the prosecution case cover the factum of recovery of the factum of the recovery of 360 kilogram of contraband ganja from the Maruti Gypsy unregistered driven by accused one is duly proved. Now the burden is upon the accused to rebut that he was not in conscious possession. Apex Court in Baldav Singh versus State of Haryana so categorically held that once possession is proved, then it is for the accused to establish that he was not in conscious possession of the contraband. The prosecution is able to prove the foundational facts of apprehension of accused with contraband ganja beyond reasonable doubt. However, the accused one unable to rebut the said presumption. Apex Court in case titled so-and-so, 2002-8 SEC 378 observed that there cannot be a prosecution case with a cast iron perfection in all respect. And it is obligatory for the courts to analyze, sieve, and assess the evidence on record with particular reference to its trustworthiness and truthfulness by a process of dispassionate judicial scrutiny, adopting an adoptive and reasonable appreciation of the same without being obsessed by an air of total suspicion of the case of the prosecution. What is to be insisted upon is not implicit proof. It has often been said that the evidence of interested witness should be scrutinized more carefully to find out whether it has ring of truth, and if found acceptable and seem to inspire confidence in the mind of the court, the same cannot be discarded totally, merely on account of certain variation of or infirmities pointed out, even addition and embellishment noticed, unless they are of such nature as to determine the substratum of the evidence and found to be tainted to the core. Courts have a duty to undertake a complete and comprehensive appreciation of all vital features of the case and the entire evidence with reference to the broad and reasonable probabilities of the case, also in their attempt to find out proof beyond reasonable doubt. Learned Defense Counsel submits that Section 42 and 57 Anticipatory Act. Lordship, I have make a reference to this paragraph before. With regard to report of arrest and seizure is not complied with by the investigating agency, but upon perusal of the evidence of the investigation officer, he has deposed to have forwarded this arrest seizure intimation letter to Superintendent of Police PAC, though the intimation letter dated 2022 was not exhibited in the court by the prosecution during the evidence of the PW6. However, there is no such question being asked to investigating agency, or this line may be important, nor to officer in charge during their cross-examination by the defense, and the reason is best known by the defense. Paragraph 38. The Learned Defense Counsel has relied his argument on various by the and the we skip this, Lordship. Paragraph 39. Lordship, 4 pages.
Yes.
Learned Defense Counsel further argued that procedure under Section 55 of the NDPS Act were also not followed by the registry officer. PW1 stated in his cross-examination that the owner of ganja could not be established, as the accused person is not clear whereabouts of the owner being from Manipur. PW1 also stated that the inventory list was prepared by the investigating officer. PW1 admitted that there is no mark or seal on the seized ganja which was produced before the court during examination. PW1 further admitted that the seized produced before the court today does not bear any proper packaging. Paragraph 40, I have considered the submission of the Learned Defense Counsel and also the facts and background of the case. I have also perused the officer previous orders of the case in hand. It appears from the order of the Learned Counsel, PAC dated 25/1/2022, the accused one was produced under arrest by UBSI Seilucha Kehe, the investigation officer, along with FIR, arrest memo, seizure memo, medical reports, accused challan, exhibit challan, and forwarding report. And on the same day, 25/1/2022, the investigation officer has filed an application praying for sealing and packaging of suspected ganja along with application filed by the officer in charge. Procedural under section 52A 2 of NDPS Act 1985, upon which the learned GMFC PEC has passed appropriate order based on the prayer of application of the PW1, and I intend to reproduce the operative paragraph of the White Order dated 25/1/2022 passed by learned GMFC PEC for the convenience of all the parties. It reads, the IO has produced a seized item, contraband ganja, concealed pack in 36 different packets. I certify that the safe inventory is as per the seizure memo, and I hereby certify the correctness of the inventory so prepared as per Annexure 1. Similarly, the prayer to take photograph of the seized item before me is allowed, and photograph of the seized item substance were taken in my presence, and I hereby certify that the same photograph are true photograph of the seized substance. The seized suspected contraband ganja are taken out from the 10 packets in random as exhibit exhibit A from so. I will not repeat. I'll skip all this. From packet number 28. And the same are taken and sealed in my presence, and I hereby certify that the correctness of the list of samples so drawn, that the representative samples, the remnant in sealed condition, the certified inventory, and the certified photograph be returned to the IO officer in charge of Procedural Police Station for continuing with the investigation. That also photocopies of certified photographs be kept with these records. Paragraph 41. This order dated 25/1/2022 passed by the learned GMFC was never challenged by the defense. In my view, there is no any infirmity in the order of learned GMFC PAC, which with regard to sealing and packaging of the seized ganja. Photographs were executed and marked as exhibit P5, and the same was not challenged by the defense during the cross-examination of PW6. The photograph clearly reveals that a huge consignment of ganja was seized. Samples were drawn, packed, sealed, and then produced before the learned GMFC PAC. Exhibit 5 is a photograph duly certified by the learned GMFC PAC. It can be safely held under section 52A4 of the NDPS Act, that the aforementioned photographs and the inventory can be considered as primary evidence relating to this offense. The accused one could not portray that investigation by PW6, who himself is a witness, was tainted. It cannot be held that the police officials acted maliciously and extraneously. The recovery and possession was proved to the hilt, and the accused one failed to rebut the same, even on the touchstone of preponderance of probability. The learned defense counsel has further argued and pointed out that the remnant of the contraband ganja was never produced before this court for exhibit by the prosecution. It is true that there is no record of exhibition. The remnant being returned to the FSL Dimapur, and the prosecution is completely silent on the infirmity committed by the investigation officer. Lordship, even here about the examination of the record of exhibition of the remnant being returned to from the FSL. This is a material infirmity in the prosecution case. However, no benefit of this infirmity could be given to
which line?
Paragraph 43, Lordship.
Remnant. Okay.
This material infirmity in the prosecution case, however, no benefit of this infirmity could be given to A1, as the prosecution case remained unimpeached of the factum of recovery of contraband ganja from the possession of A1, accused one at Razaba Gate, Procedural on 19/1/2022, while conducting MVC B, by the police officials. On cumulative appreciation of the evidence despite lapses, lacuna, and discrepancies, as discussed, the prosecution able to prove the foundational fact against accused beyond reasonable doubt. On overall appreciation of the evidence on record, the prosecution able to prove that 360 kilograms of contraband ganja was unloaded in unregistered commercial gypsy inside the tarpaulin, which was driven by accused one, and there was no other passenger except one. Therefore, there is presumption under Section 35 and 54 NDPS Act of culpable mental state and conscious possession in favor of prosecution. As accused one utterly failed to rebut the same either through prosecution evidence or his own explanation. Lordship, accordingly, he was found guilty. Lordship.
What is your submission regarding the submission by the learned counsel for the petitioner that the seizure and arrest, search and seizure was made by unauthorized police official? Mandatory provision of Section 42 was not followed.
In the absence of
Whether that was addressed by the trial court or even if not, what is your submission?
Lordship, like a report was submitted, not on the not indication of the report of submission was there, Lordship, about the arrest and all these things, Lordship. And in the absence of the officer, I think regarding Section 42, if I may take my lord's judgment by my lord and my lord, Manish Chaudhary. Here I'm trying to take my lord to the Supreme Court citation regarding Section 42, Lordship. Page 37. Page 37.
Is 37?
Yes. Page 37, paragraph 35, Lordship.
Yes.
Narrate. The provisions contained in Section 42 as a whole has come for consideration before a constitutional bench of the Honorable Supreme Court of India in Karnal, Singh versus State of Haryana, reported in 2009 8 SCC 539. After surveying a number of precedents, the constitutional bench has observed as under. In conclusion, what is to be noticed is that Abdul Rashid and so did not require literal compliance with the requirement of Section 2.1 and Section 42.2, nor did Sajam Abraham 2001 and so hold that the requirement of Section 42.1 and 42.2 need not be fulfilled at all. The effect of the two decisions was as follows. A, the officer on receiving the information of the seizure referred to in section subsection 1 of the Section 42 from any person had to record it in writing in register concern and forthwith Lordship send a copy to his immediate official superior before proceeding to take action in terms of clause A to D of Section 42 subsection 1. B, but if the information received was when the officer was not in the police station, but while he was on the moved either on patrol duty or otherwise, either by mobile phone or other means, and the information calls for immediate action, and any delay would have resulted in the goods or evidence being removed or destroyed, it would not be feasible or practical to take down in writing the information given to him. In such a situation, he could take action as per clause A to D of subsection 42 subsection 1, and therefore as soon as practical record the information in writing and forthwith inform the same to these official superiors. C, in other words, the compliance with requirement of subsection section 42.1 and section 42.2 in regard to writing down the information received and sending a copy thereof to the superior officer should normally precede the entry search and seizure by the officer, but in these special circumstances involving emergent situations.
In the instant case,
Yes.
whether the search was made on the basis of prior information or whether it was routine checkup, on what basis the vehicle was searched?
Here is said that during, it appears during checkup.
Routine checkup.
Anyway, since information instantly at the right instant, there was no officer, so intimation was made and the OC arrived, and a formal, as per the judgment, a formal arrest was made.
But this decision which you are citing,
Yes.
here the search and seizure was made by authorized officer. Either the officer has to be empowered officer under section 41 or authorized by an empowered officer. In the instant case, neither you were empowered nor you were authorized to conduct search and arrest. You could have informed your superior, an empowered officer, before access. Under what authority the PW2 conducted the search and seizure? What was his authority?
Lordship, what is stated here?
Because NDPS Act clearly lays down who are the category, what are the category of officers, or who are the officers who can conduct search and seizure without warrant, and under what circumstances search and seizure. Normal procedure is that search and seizure has to be done after obtaining warrant from the competent magistrate.
Lordship.
But who are the officers and under what circumstances search and seizure and arrest can be done even without warrant has been specified in article section 41 and 42. So my query to you is, under what authority PW2 conducted search, then he arrested the appellant? What was his authority?
That was not the authority given to the PW2, as far as my findings concerned. It's not indicated in the here.
There is no indication.
As far as my indication is concerned, Lordship. But the formal one thing has to be kept in mind is that, Lordship, the formal arrest was made after the arrival of the OC, Lordship.
Okay. So it was the OC who arrested the. Then whether OC followed 41, 42. OC has to inform his superior officer.
Yes.
That was not exhibited.
Yes, but it was not raised, Lordship.
The
That was
the trial court said that it was not raised before, therefore it may be condoned. But it was the duty of the prosecution to prove compliance of mandatory provisions of NDPS Act.
shipping that
This judgment which you are citing, the division bench judgment, it says that total non-compliance is impermissible.
Lordship.
delayed compliance with satisfactory explanation about the delay will be
Yes.
acceptable.
Yes.
Whether that was done in this case. Delayed compliance and then explanation why the 41 and 42 could not be complied with.
That detail was not shown, but what is shown here, what is shown here is the letter was sent to the superintendent lordship. What was-
Only oral testimony.
Yes, yes.
Oral testimony that a letter was sent to the.
So what is in the text of the letter that lordship I have sorry that I've not seen that lordship.
Because it was not exhibited before the court. Okay.
Okay, with this, conclude my submission and by saying that there's no infirmity in the judgment passed by the learned trial court below lordship. And the appeal is liable to be dismissed.
Lordship, I'm allowed to make a short reply on the questions raised by my learned friend, Lordship. Lordship, whether section 42 is mandatory or not is already well settled, Lordship. In the same volume, Lordship, 2010 3 GLD, which I have placed before my Lord. There is another division bench decision in page 454 in that same volume, Lordship.
Give me the citation.
2010 3 GLD 454.
2010
10 3 GLD 454. Earlier, from that same volume, I have relied on 361, paragraph 24. Here, I believe it will be paragraph. To paragraph 18, I have highlighted the relevant portion. Towards the end of the paragraph. 18 is quite a long paragraph, Lordship. But it is categorically held by the division bench that section 42, section 50, these are mandatory provisions under the NTPS Act, Lordship. Now, in paragraph 37 of the impugned judgment, Lordship, they explain the reason for rejecting, Lordship, the non-compliance of section 42 is that the questions regarding the search, seizure, and arrest were not put to the IO and the OC, that is PW1 and PW6, Lordship. However, Lordship, PW2, who made those seizures, search, and arrest, questions were put to him, Lordship, which I have already read out. PW2, Lordship. He was the one who made the search, seizure, and arrest, Lordship. And Lordship, under the CRBC, there is no distinction between a formal and informal arrest, Lordship. Arrest is arrest, Lordship. So, Lordship, what cannot be done directly under the law cannot also be done indirectly, Lordship. So once the arrest is made by the constable, Lordship, again, whether a formal arrest can be made, Lordship, by the OC, Lordship. That is illegal, Lordship. Not permissible, highly impermissible in law, Lordship. Now, my learned friend has also raised the issue that the date, which is reflected in the FSL, Lordship, has not been raised, Lordship, and also the Malkana register, Lordship, not been produced before the court. These issues were not raised, Lordship, before the trial court, Lordship, and also in the appeal. However, my Lord, these are things which are apparent on the face of the record, Lordship. The LCR, which is undisputed, and which is the FSL report is a document of the prosecution, Lordship. It is not my invention, Lordship. It is already on the record of this honorable court. And when that defect was there, Lordship, that date, Lordship, the prosecution should have made corrections, Lordship. before submission of charge sheet, because along with the charge sheet, the FSL report is usually submitted, Lordship.
Or trial court should have considered, while considering the said document,
Yes, Lordship.
should have made an observation.
Yes,
Why it is
Lordship.
relying on that document.
Lordship, my lord. Now, my lord is well aware that question of fact can be raised in first appeal, Lordship. On that, Lordship, I may not be, in order to save time, I may not read the paragraph, Lordship, but it is, the judgment I'm relying on is 2001, 4 SCC, 756, Lordship, paragraph 5.
Please read.
5. We have carefully perused the judgment and decree of the High Court in the first appeal. We find that the substantial documentary evidence that had been placed before the trial court, including certified copies of certain public records, besides copy of the judgment and decree of the earlier suit. Oral evidence had also been led by the parties before the trial court, which was noticed and appreciated by the trial court. However, the impugned judgment in the first appeal is singularly silent of any discussion either of documentary evidence or oral evidence. Not only that, we find that though the trial court had dismissed the suit on the ground of limitation, as also on the ground that the decision in the earlier suit operated as res judicata against defendant number 1, the High Court has not even considered, much less discussed, the correctness of either of the two grounds on which the trial court had dismissed the suit. Sitting as a court of first appeal, it was the duty of the High Court to deal with all these issues and the evidence led by the parties before recording its findings. It has failed to discharge the obligation placed on the first appellate court. The judgment under appeal is so cryptic that none of the relevant aspects have even been noticed. The appeal has been decided in a very unsatisfactory manner. First appeal is a valuable right, and the parties have a right to be heard both on questions of law and on facts, and the judgment in the first appeal must address itself to all the issues of law and fact and decide it by giving reasons in support of the findings.
Yes, but this was a decision in a civil suit.
Yes, Lordship. Yes, Lordship. But the principle applies, Lordship, that in first appeal, the question of fact, Lordship, can be entertained, Lordship. Now, Lordship, the discrepancy in the timing of the FIR, Lordship, and Lordship, the issue of debt, which I have already raised, the non-production of Malkana register, Lordship, and the non-production of the remnants before the trial court, Lordship, that is the samples before the trial court, Lordship. All this shows, Lordship, that the investigation.
Was there an obligation to produce remnants?
Yes,
Why?
Lordship.
What the prosecution would have shown? Because the remnant, what prosecution is required to show that this
Lordship,
was seized?
Yes, Lordship, yes.
This
Yes.
contraband was
Yes,
seized.
because a number is given in the, which is reflected in the FSL report.
No,
Lordship.
why the prosecution
Now-
is required to prove, to exhibit the remnants? Why? To show what?
To show that, Lordship, those were the actual samples from which the FSL report was made, Lordship, in order to show the link between the FSL report and the samples, Lordship.
Therefore, remnant is also.
Yes, Lordship, Lordship. Now, Lordship, I am saying that.
But that can be proved otherwise also.
Yes.
Suppose the test memo,
Yes, Lordship.
which accompanies the sample is drawn from the contraband
Yes,
in
Lordship.
front of magistrate. Magistrate certifies that sample is drawn.
Yes, Lordship.
A test memo is prepared
Yes, Lordship.
containing list, quantity, other
Yes,
description of the
Lordship.
samples. And
Yes.
that is sent along with the sample to the
Yes,
FSL.
Lordship. Yes.
In that test memo,
And-
the date is.
And Lordship, that remnants, Lordship, must be sent and produced because, Lordship, we must be satisfied, Lordship. The courts must be satisfied that it was actually the test and the samples, Lordship, they match each other, Lordship.
Okay.
Now, Lordship, all this, it shows that the prosecution had conducted the investigation in a casual and shoddy manner at the cost of my precious rights, Lordship. Lordship, I may be allowed to place a decision, Lordship.
You have cited so many decisions. Then you have to give in a page, separate page,
My lord.
that this decision, on
Lordship,
this point
Lordship.
you are
Relying on. Lordship.
relying on.
Yes, Lordship.
Yes.
Paragraph 15, Lordship.
Yeah.
15, my lord.
Yes.
The police investigation was very extremely casual, perfunctory, and shoddy in nature. The appellant had been denied the right to a fair investigation, which is but a facet of a fair trial guaranteed to every accused under Article 21 of the Constitution. The consideration of evidence by the trial court, affirmed by the High Court, borders on privacy to arrive at conclusions for which there was no evidence. Gross misappreciation of evidence by two courts, let alone poor investigation by the police, has resulted in the appellant having to suffer incarceration for an offense he never committed. And Lordship, my learned friend has also heavily canvassed, Lordship, on the burden of proof, Lordship. By reading out, Lordship, paragraphs from the judgment under challenge, Lordship. Now, in that same decision, Lordship, in paragraph 10, it's 202, my lord. The judgment starts from 202.
Yes. There are 10.
Yes, my lord. The stringent provisions of the NTPS Act, such as Section 37, the minimum sentence of 10 years, absence of any provisions for remission, do not dispense with the requirement of prosecution to establish a prima facie case beyond reasonable doubt after investigation, only after which the burden of proof shall shift to the accused. The gravity of the sentence and the stringency of the provisions will therefore call for a heightened scrutiny of the evidence for establishment of foundational facts by the prosecution, Lordship. Now, my Lordship, I humbly submit, Lordship, that the foundational facts they were unable to establish because FIR, Lordship, the timing in the FIR, they were unable to prove, Lordship, satisfactorily. The FSL report, Lordship, which is a principal document, Lordship. Lordship. Therefore, and Lordship, regarding 313 also, Lordship, my learned friend has raised. I'll be making a short submission on 313, Lordship. My Lord is well aware, Lordship, 313 is not evidence. Despite that, Lordship, question number 3, which my learned friend has, out of 8 questions, the 3rd question, Lordship. Now, the other 7 questions, Lordship.
He has not admitted, actually.
Yes, he has not admitted,
He's
Lordship.
only saying
Yes,
that
Lordship.
you
A specific question should have been put to him, Lordship, that were you aware that you were that vehicle had ganja in it, Lordship? That question is not there, Lordship. And just by reading between the lines, Lordship, by making assumptions, Lordship, an accused cannot be convicted under the NTPS. I'm deeply obliged for giving me a very patient hearing, my lord.
Appeal it with the report. This 25% of,
my lord,
will you be submitting on your, or you are not pressing for that? That
Modi's, Lordship, I'll check it up, Lordship, in Modi's, whether it is. Actually, to be very honest, Lordship, I tried to find that relevant page also earlier, Lordship, under the impression that it was Modi's toxicology, Lordship.
It is not Modi's.
Yes, Lordship, yes. And it's quite a big book, Lordship.
So you are relying on the judgment which you have said?
Yes, Lordship, Lordship, Lordship.
Okay, I am reserving it. Heard Mr. Sinti Angel, learned counsel for the appellant. Also heard Mr. KV Angami, learned public prosecutor. Hearing concluded, judgment reserved.
Deeply obliged, Lordship.
Would be convenient for me if you can provide a
By tomorrow, Lordship.
by tomorrow
My
the
lord,
citation which you are relying on.
my lord. my
You
lord.
have relied upon only one citation, no? That is okay, but you have to provide.
My lord, my lord. I'll do that now. Deeply obliged.